Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
It had a barrel, and then there was a valve that would open rapidly. And directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel would determine essentially the speed at which that glass would be projected into the taillight. Yeah, it's pretty awesome.
Cool job.
You can't deny the science and the physics as to what would have happened if he was struck by the vehicle. So anything past that, you have to somehow overcome that hurdle, which is very difficult to do. You can't deny the science and the physics.
Oh man, was yesterday fun or what? Oh my goodness. Welcome, good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for being here. I feel like I was just here. Oh my goodness. Good morning. I am here. I'm awake. I got plenty of sleep. One of those things is a lie. But here we are. Oh wow. We have a terrific Tuesday lined up for you today, where we are starting. We have. I guess you could say technically we've caught up to the Karen Reed case because the defense arrested, and I told you when we get to the end of the case, I want you guys to be caught up so that you can watch it live with everybody else. We're not going to follow live Karen Reed closing arguments. Here's how it's going to spell out today. We're going to be very close, but here's how it's going to spell out. We're going to start with Wade Wilson. Wade Wilson closing arguments in the sentencing phase start this morning, like in 15 minutes. That's where we're going to start. We're going to stick with that live and until we go into verdict watch. And once we go into verdict watch, we're going to go back and start watching the closing arguments in the Karen Reed case. This will get you, and we'll be in verdict watch for Wade Wilson. So that's gonna be how we move forward through those closing arguments. Closing arguments are only going to be a couple hours, I think, for Karen Reed. That'll take us to noon. Even if they have a very quick verdict in Karen Reed case, I believe we'll be able to do it in this order and not be rushed. So we'll be a little bit behind. Each side gets an hour. So yeah, so we'll have the closing arguments then. So we'll watch those an hour or two behind. Then we've got verdict watch there. We expect a verdict to come back in the probably a quick verdict during the closing arguments of the Karen Reed case. We expect a verdict in Wade Wilson. That's me personally. I think that's going to be a quick one, mostly because the defense didn't put on a case. But they're going to decide life or death, and we'll figure that out now. So what I'm saying is we're going to have whiplash again. We're going to have whiplash. We're not doing it in that other order because I agreed not to cover the Karen Reed trial live. I would highly suggest you watch with Brandy Churchill. Well, if you really want to watch it live, which I would like to do as well. So on the verdict, when the verdict comes in for Karen Reed, I'm going to turn off the live stream and go over to Brandy Churchill's channel and watch it with her and just enjoy hanging out in chat and watching everything. That's my plan. After that, we will do a wrap up live stream for that. We'll recap the verdict in the and we'll probably play the verdict music in the Karen Reed trial. That's my plan right now. I just wanted to let you know up front. I don't want to disappoint anybody. Why are you guys so sleepy? What's up with everyone lurking around and dragging their butts in the courtroom slowly? I got like 7.5 hours of sleep, which is beautiful for me. We have to, first of all, before we go too far, we have to properly thank Golden Girl, who once again won first in chat. It's been a long time, Golden Girl. You've had months of good behavior, and then this, I guess we can only call it a relapse, because that's clearly what it is. You've gone back to your old ways. You've won the chat once again by being first in chat. Congratulations-ish, I guess. Excited to give you the internet. We're going to go ahead and gift that to you now. And Lenovo, hopefully your internet is not giving you problems, Lenovo. The internet didn't like you because you re-gifted it, and it just treated you badly after that point. It was like a rough breakup. But thank you very much for your generosity, Lenovo. Hopefully chat is working for you just fine this morning. Let's see. Anything else? Yes, Golden Girl. Make sure, I think you have one from before. Make sure you have you've paid your low fine of 50 cents and ordered your downloadable fill in the blank copy of your criminal record, indicating that you did own the internet. Buffer. Looks like we have Haley celebrating a birthday today. It's always good when there's at least one person to sing to. So we'll go ahead and sing happy birthday to Haley. By that I mean all of us. Oh, yes, I'm looking at you. You're thinking, no, they'll sing. No, you will sing with us. Nod your head. There you go. You will sing with us. That's what we're going to do. Oh, my goodness. Let's see. I need to find the birthday music. Honestly, my goal is not to fall asleep on stream today because so much is happening. But I'm not sure if I can keep that promise. Warm up with me as we sing the birthday song for Haley. La 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 la. That was a good one. All right, dancers at the ready. Blend your voices with mine. Loud, wherever you are. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Haley. Happy birthday to you. Haley, it's your birthday. It's your birthday. I have something for you. I was actually scrolling on Facebook, and I think Denise posted this. A list of things you can get free on your birthday in like June, July area. I think it might be just be July, so maybe this doesn't apply to you. But free scoop of Baskin Robbins. You've got a free drink at Caribou Coffee. Free cookie at Crumble Cookies. Free bunslet at Bunt Cake. It's a bunt cake. Free stack at IHOP. I guess they're joining in the Denny's deal. Free snack size wings at Buffalo Wild Wings. All these companies may or may not be going out of business. I make no representations as to their availability when you go to visit. But Haley, I realize there are a million places you could be, a million people you could celebrate with, but you've chosen to be here with us. Thank you very much. Hopefully we can make your day a little specialer by having a couple verdicts for you. What do you say, everybody? Yeah? That would be awesome. That would be amazing. Haley, happy birthday. Happy birthday. Hope you have a great one. Great one. All right. We're gonna 80s Music Man suddenly appears out of nowhere because someone gave him control to the Ninja Finder, and I cannot see him until he turns it off. I don't know why. I need to run a script that will hunt him down. We need to figure out AI. All right, so where are we? Where does that leave us? I think we're getting ready for Wade Wilson. Does that seem fair? Okay, let's back up. I need to. Alrighty. Let's see. Trying to figure what time it's going to actually start, because that's sort of important. Okay, where are we? I think it's 9. Don't think we have a feed yet. So let's see. Well, maybe we do. Okay. Yeah, we're good. We've got everything covered. Let me get audio on that. It's good. Now we need Karen Reed's going as well. Let's see, which one do we want to record? How much notice needed for a weekend birthday? Alita, we can sing on Friday. We'll sing on Friday. Hang on, I just got a text. I'm not sure if I can read this out loud, but okay, I can't read that one out loud. That's funny though. All right, where are we? Yo, mama, welcome. 14 months membership milestone. Fingers crossed for Verdict Music 2 times today. Sharon was going to add you on. I guess that you've noticed is enough. Thank you very much, Sharon, for keeping track of that. Amazing benefit for the channel and for everyone who's celebrating birthdays. All right. You love IHOP. You don't have it there. Why would you move somewhere without an IHOP? Asking for a friend. I didn't know there were places without IHOPs. Honestly, I didn't know that. All right. Oh wow. Let's make sure everything's working right. There's Wade Wilson, or there's where Wade Wilson will be in just a couple of moments. So we've got audio from that. We're good there. We need. Who else? We need Karen Reed on 3. So I'll keep an eye on what happens there. It's like a circus here this morning, only I'm very, very sleepy. Is that closing statements? That is live. That's closing statements. Okay. So we have a little fan going, little fan action. It's the only fan in the courtroom. Usually that's a bad thing, but we'll let it slide today. Kim R's like, wait, you're sleepy? Kim, you went to bed early. Kim, you dropped out. Ashley, I have an emergency bottle of Mountain Dew that's been chilling in the fridge for almost a month now, and it's my goal to not use it today. I'm just going to try to drink enough water to not be able to sleep. His voice made me fall asleep around 11:30. Well, at least you didn't fall asleep to What If Any's, because he was on Cross, which I actually like better than his direct. But all right, one little update, just for your information. On 5/7/24, how many days has it been since 5/7/24? It's almost been 2 months, right? Jill De Jesus, welcome to the gallery. Thank you very much. Love that you have Yellow Courthouse by your name. That means at least 6 months of support. Thank you for that. Congratulations on your anniversary. We only missed the last hour last night. I caught it this morning. Good job, Paula Mack. I'm sorry I kept you guys up late. That was with no warning. Dadu, do you hear the theme song in your head? No. Anyway, 5/7/24. How many? It's now January, February, March, April, May, June. It's now 6. I had to count on my fingers because it's one of those mornings. It's now 6/25 of 24. So we're a month and a half, maybe a month and 3/4, roughly. That's how long ago I ordered my replay keyboard. And it still shows as back order waiting for items. And I'm number 1 on the list. Let's see. Did you love the Canon from last night? Oh my goodness, the Canon was absolutely amazing. The best part about it was the smile. Okay, so let me replay if I can, just briefly. Let's go here.
It had a barrel, and then there was a valve that would open rapidly, and directly behind that was a pressurized vessel.
Look at this guy's smile.
And depending on the pressure, the PSI of that vessel, would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
He's all like, yeah.
Yes.
Let's see. Where was that again?
Projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
Pretty cool job.
You can't
Pretty cool
deny
job.
the science and
Sorry. And then I've got that one. You can't deny the science right after him. Anyway, good. It was amazing. Those two sound bites were probably my two favorite from yesterday. You can't deny the science. It's like the math. The math is not mathing, Mr. Lally. And the fact that it came out, I believe that was on cross-examination where Mr. Lally was asking him questions. That's for the soundbite to drop on you. That's like being dunked on in the NBA. That's like being posterized as you're getting dunked on in the NBA. It's beautiful. It's absolutely amazing. While we're waiting for Wade Wilson to begin, which we'll watch right here, let me tell you where I'm at now, because I've sort of been sharing my personal journey in this on where I stand on the Karen Reed trial. And for a long time, you guys gave me a hard time because I said, I believe, and I stuck by that something happened with Karen's car there at the in front of the Albert's house. And I felt that way because for me, when I looked at the video of her pulling out of the driveway, I did not see anything. I haven't made the command yet. I'm not sure if we're going to do a canon command. We're definitely going to do you can't deny the science command. What would the command be? Would it be like Bill Nye? What would you? No, I'm not sure if he's the best example we can use. We'll figure it out. Anyway, watching the video of Karen's car pull out of the driveway convinced me that the taillight had been broken and pieces had fallen out previous to that trip. And because they were recovered at the Albert's house on the lawn and everything, it convinced me that it was broken there, because that was before anything had happened. That would require a level of conspiracy and planning that just did not exist. And I was stuck on that, and a lot of that made me think that that there was a hit, that something hit her car. And yesterday, when we heard Mr. Wolf testify that they were able to perfectly replicate that damage, or not perfectly, but replicate that damage by firing a cannon with a drinking glass at the taillight and get that area of damage with no damage around it, have broken glass, have broken taillight and everything, that made sense. And you've got John and Karen in the car. They're fighting. We know they were fighting because they were fighting before. They were fighting after, or at least Karen was leaving messages after for him. They sat out there in the car for a while. Whenever John got out, I imagine the passenger window rolled down and some choice words were said back and forth. And John, with his alcohol level, what was it? Was he at like a 0.28 or something? It was high, right? It was high. Probably had enough and chucked the glass at the car as he's walking off. As I don't know, maybe Karen's driving, John's walking away, he chucks the glass, nails the taillight. Karen puts it in reverse and zooms back to yell at him some more. And I don't think any contact happened there because there's no other damage. But now that leaves me with this weird situation where I cannot account for any of John's injuries based on the car. Any. Zero. Which means the case is over. And the jury is in the awkward position of feeling compelled or having a desire. There's a natural desire to close the case, to put the pieces together, to finish the puzzle and say, this is the solution, we've solved it. And that is not their job. We are missing the pieces in evidence that tell us what happened to John O'Keefe. It's not there. But based on the testimony that I heard yesterday, and I believe, and I found incredibly credible, I guess, can you do that? Incredibly credible? Based on that, I cannot see a conviction occurring at any level, no lesser included. There is no level. I mean, can you convict somebody for fighting, for arguing with somebody about a relationship? No, that's not a crime. I cannot see a conviction coming through with this very, very compelling evidence. Now, what about the hair on the back of the car? What about the DNA, touch DNA? And yes, I have reasonable doubt about some of the evidence being padded by Mr. Proctor. I have reasonable doubt. Anyway, it is tough. We like to think that the victim gets justice and the families get closure, and the culprit gets locked away. But we don't have the right pieces for that recipe to occur today. I don't think we do. Anyway, that's where we are. Let's see. We're waiting. We're supposed to have the jury back right now with Wade Wilson, and I'm not seeing it. Tom, I agree with the judge on this one, and let me tell you why. The way the law is written on a judgment of acquittal, or that basically the motion that the defense made as soon as the state rests, saying, Judge, they haven't proved their case. You got to throw this one out. The standard is so low for the state at that point that if there is any evidence that a juror could construe as supporting the charge, it basically goes through. Even if the judge can't weigh the evidence and say that's not very good evidence. If there is any, it has to be looked at the light most favorable to the state at that point. So I think the judge did right in letting this go forward to the jury. But that's my take on that one. Oh, Wendy, O'Hare in a lightning storm. Man, I am sorry. The airports are just not designed for long-term stays. Anything over about an hour is just not fun in an airport, unless you have like some sort of club membership that that I do not have. There might be a room with soft leather seats, comfortable seats that are clean and quiet, and people come and feed you grapes and wave palm fronds over you. But I've never found that room at an airport when I've been traveling.
Okay.
Here we go.
Okay.
He just needs a minute.
That's fine.
The Wade Wilson jury is over at the Karen Reed Courthouse wearing pink.
Hey, Judge, I'm going to need some exhibits before I do mine.
Sure.
So can we take a short break? Give me
We're in informal recess right now, so you can talk to the state, go to the clerk, whatever you need to do.
Well, they may be using some of the same exhibits I need. So.
That's what I'm saying. You
Just
can talk
talk
to the
to
state
them.
and go over that.
Honestly, they're people and they listen.
No, that's fine. You approach the clerk?
Yes, absolutely.
Others testified a small crack in the light, even the officer.
Yeah.
I think snow on the taillight could have
thank you.
obscured that. It could have looked like there was snow when instead it was broken out. I don't know. That piece of evidence doesn't bother me a ton. I do also think that it's still very possible for Proctor to have placed additional taillight at the scene and have placed fragments of taillight on the clothing. That's a tough one. That's a tough one because that basically is me saying that I have reasonable. In my head, I can get to the point where Proctor commits a felony in order to close this case out. And I think planting evidence, isn't that a felony? Falsifying evidence. It's just a reasonable doubt that it could have happened. And that conclusion comes based on the opportunity I witnessed in the video, the communications he had with his friends, that to me speak to that is the effort that he was putting there. That's his goal to accomplish, and the inconsistencies and improprieties of the handling of evidence that went through him during the time prior to them being tested. A defendant will be brought out at the last minute. I'm not sure what the delay was exactly. Audio sort of came in late. The court clerk having accidentally dressed in identical outfits as the defendant, has gone with a pure white outfit today in the hopes that, that she's not wearing the same thing as Wade Wilson today, the court recorder. She's worn the same jacket, and it's been sort of funny. No, but I agree. If they had said he had knocked him down and not put out a scenario that could be debunked by physics and math, it is really hard to, in the face of a very clear mathematic equation, believe that the 2 + 2 does not equal 4. I said that wrong. It's hard to believe that 2 + 2 = 5 when we know that 2 + 2 = 4 and we can do the math. But the state has us saying that 2 + 2 = 5 in this case, and it's just not adding up. Had they had a different theory, honestly, had they had a better crash reconstruction expert that came up with a better theory of how this happened, that still fit within the parameters of all this, it would have been easier to believe. But anyway, Wilson will not be in stripes today. Apparently, he gets street clothes throughout this. The cannon maker blasted the defense out of the water. Or sorry, blasted the prosecution out of the water. I get them all mixed up. Might have a defendant coming in. That's the door he comes through. I see they put the tallest bailiff they have in charge of guarding that door. The other bailiff's looking for his tie. Look at him laugh at him. Forgot his tie. Still getting dressed this morning. Sorry, Judge, I'm late. He's in the corner doing a double Windsor. Full Windsor. What could have made yesterday better? What would have made it better for me is if for some reason Lally had opened the door and allowed the fact that the FBI was who hired the cannon guy to do the FBI Department of Justice. That it was. I think everyone can draw that conclusion. But if that had just dropped, that would have been perfect, because he would have tried to backtrack and scramble and cover his tracks. And once the door's open, it's open. The other thing is if our cannon demonstration was filmed in like a YouTube video style, like, I don't know, Smarter Every Day or King of Random or something like that. If he had done his tests that way, and we had like the full video to watch, and at the end he's like and subscribe, that would be amazing. I don't know. That it was a pretty good day yesterday. Who rejects an FBI affiliate who makes cannons as their witness for free? Yeah, these two witnesses, you cannot get higher quality, impartial witnesses. If you're going down the list of expert witnesses that are available for prosecution and defense to testify in your case, these guys are they're well above the $10,000 base rate fee, which we've had a lot of $10,000 experts, especially in like Wade Wilson. They'll do $10,000 worth of work, regardless of how much work it is. It will be $10,000. These guys they're like in the $30,000 range, and they're impartial. And defense got them for free. They got them for free with a subpoena. It was good. Mythbusters, slow-mo guys, all good ways to. I think slow-mo guys is probably my favorite. Can you imagine the taillight shattering in slow-mo at 26,000 frames per second on a Phantom replay machine? Oh man. The Creative B, here's where we are. We are live with Wade Wilson. I can tell you that. Let's see, where is it? Right here. This is live with Karen Reed. We're both waiting for trial to start. We're going to stick with Wade Wilson. We think this will be a quick closing, both from the state and from the defense, and then it's going to go to jury instructions and verdict watch. At that point, we're going to go back and start watching this morning's closing from Karen Reed. So we'll be a tiny bit behind. We won't be live in the closings, but we expect to be able to finish the closings while they're still in verdict watch and deliberation on Karen Reed. Sometime during that, probably while we're watching Karen Reed, this is my faith in what's going to happen in this Wade Wilson trial. Sometime while we're watching the Karen Reed closings, we're going to have to interrupt and jump back to Wade Wilson because I think we've got a quick verdict. I think so. I don't know. It's a Florida jury. Anything can happen. But we'll keep an eye out for that if we have a verdict. So we'll do that live. Then when it actually comes to watching the verdict in the Karen Reed trial, I'm going to be watching on Brandy Churchwell's channel. I would invite you to join me. I'll be over there in chat. I haven't made arrangements for her to be on stream with her. I don't want to inject myself in her court process. She's done an amazing job, and I want to watch it from her perspective. Once that's over, we'll come back and do a little delayed verdict watch here on our channel. Does that work? And I'm just doing that because there are some people who watch this after the fact. I mean, there are people who are right now who are watching the old trials. Letitia Stout, and I'm getting comments from people. I'm working my way through the Letitia Stout videos. They like to watch, and I'd like to have a bookend on the tail end with a verdict for that. So that's the plan. We'll do our verdict watch party, but it will be a little bit late. I'm going to watch it live with Brandy. So, not sure what's happening here. I've never seen a courtroom like this where there is a delay, where the judge just chills on the bench. He's always like, "Come and get me in my chambers. I'm taking this robe off as long as I'm not going to wear this 1 minute longer than I have to." But this judge just, I don't know. Maybe he's got like a really cool version of Solitaire up on his computer. He's just happy being right there. All right. We will have verdict music. We'll have verdict music for Wade Wilson, and then delayed, we're going to have verdict music for Karen Reed, if that comes in today. And just look at this. So let's back up and talk to Karen Reed just a little bit, and look at it as we're viewing the jury. As you're watching this, up until yesterday, I believe there were a lot of people who, on each side, there are people who have looked at the evidence and have come to a conclusion, and they're welcome to do this differently than mine. That's fine. But if that has happened, I think the jury has people who probably think that Karen Reed did it. It has people that probably think Karen Reed had nothing to do with it. So those two options exist. As long as they're there, it could be a long deliberation. So we're watching it live on Brandy's channel. That's the goal. And then we're going to come back and do it on my channel after. Just for the playlist. Wade's still trying to find the right tie to go with his orange suit. He'll have time to do that, I think. Are we watching both closing arguments today? Yes. But we'll be delayed on the Karen Reed closing arguments. So we'll probably be a couple hours behind. You think the jury's wearing pink? I don't think they would have done that. That's a pretty bold move. I'm guessing it's hung. The last 5 court cases have been flipping hung, says Mel. We have had a few that ended that way. Braxton says, my call is they both come in the same time tomorrow. Charge up the tablet, Lacey. It's going to be a terrific Tuesday in the world of true crime. Grace Sanchez says 1 year and 13 days. I don't know how many more months non-member. Thankful I made the awesome decision to join our team. Grace, thank you very much. Thanks for the super chat. I love it. Appreciate your support. Jen saying today for Wade Wilson, tomorrow for Karen Reed. What's the favorite case you've covered so far? Let's see. What was the gentleman who was charged with murder served like 2 years in jail? I think it was Arizona or New Mexico. I think it was Arizona. He was accused of shooting the guy he was buying land from with the AR-15, and he replicated the defense attorney had him pick up the gun and act like she was the bad guy and demonstrate. That was probably the favorite, and for a couple of reasons. First of all, he maintained his innocence all the way through there. Cummins, was it Dean Cummins or something like that? I can't remember his name. Not Rittenhouse. I didn't follow Rittenhouse. We followed a different trial from the same judge, though. That was Zachariah Anderson. I like that because he did everything that I thought he shouldn't do, and he was right. I had looked at that case and said, "Here's the best bet you can go for." I don't remember if we were looking at hope for a lesser included or something, and he stuck by his guns. He stood up. He testified in his own defense. He reenacted the scene of the shooting, and was perfect with it. We've got screenshots of him holding the actual AR, and it's pointed at the defense or the prosecutor, who's it was mind blowing that way, and he was vindicated. Came back with not guilties. I think it was Dean Cummins. That was one of my favorites. Letitia Stout was a very tough one. Very, very tough. McCabe's and Alberts are in the courtroom for Karen Reed, apparently, but the fan is still spinning. River Valley stabbing trial was wild. How did that one end? Was he convicted? Why can I not remember how it ended? Yes. Karen joined us with Letitia Stout. That was I enjoyed the community that gathered and watched for that one. That was fun to be together for that one. We got some.
All right. Let the record reflect: the state's present, defense counsel, and the defendant are all present. Is the state ready to proceed this morning?
Khakis.
Yes, sir.
Is the defense ready?
Yes, sir.
Okay. Let's talk about jury instructions. I've got an updated draft from the state on the final instructions. I've read through that. Part of what I believe, though, needs to be done is because you have separate counts of first-degree murder, I believe the instructions as to aggravating factors and mitigating circumstances should be read as to each count, because I think it could be confusing to the jurors as to aggravating circumstances related to count 1 as opposed to aggravating circumstances or factors related to count 4. Same with mitigating circumstances. I know we discussed this yesterday, and the defense was okay with having mitigating circumstances apply to both generally, but I think in the abundance of caution, it's better to read them over again for each count. I don't mind reading them. So I'm looking at these. I know it's not quite, it's more in line with what we talked about yesterday, but I was able to give it some thought overnight. Any thoughts on that from either the state or defense?
Yes, we're going to cover Sarah Boone.
Because you have two separate events with two separate victims in each count. And so, and I noticed, like in the aggravating circumstances, you allege, I think, number 6 regarding or maybe mitigating circumstances about returning Miss Ruiz to her family, that may not apply in the count with Christine Melton.
I think he can't sit straight up because of the shock device on his waist. We don't have mics on the prosecution right now. We'd ask for no spoilers about Karen Reed, so when that one does start, let's not.
No.
We don't want running updates.
But the instructions regarding aggravating factors and mitigating circumstances, I believe, should be read each for each count.
So we would start with the paragraph that says first, each of you must determine whether any mitigating circumstances exist.
I think that in making your decision, something to delineate that at the beginning of the final instructions of penalty proceedings is the heading of the first page. And it says, members of the jury, you have all heard the evidence of the argument of counsel. Now you must decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. That applies separately in each count. They may make one finding in one count and a separate finding in another count, or both the same, but each count should be considered individually. In other words, they can't take and weigh aggravating circumstances as it relates to count one and apply those to count four, I don't believe, or vice versa.
I may have a solution, Judge. May I remain seated?
Sure. Just speak up a little louder for us.
You got it, Your Honor. There's an instruction in the general instructions that talks about single defendant, multiple charges. Would court be amenable to having something along the lines whereby we propose language that tracks that particular instruction but applies to death penalty? And what I would be suggesting would be something along the lines of the evidence that you have heard throughout the guilt and penalty phase of this trial should be considered as to each of the capital felonies for which you have found the defendant guilty. Count 1 and count 4 of the indictment. However, in making your determination, you must consider whether the state has proven each aggravating factor beyond a reasonable doubt with respect to each capital felony individually. You must not let your verdict as to one aggravating factor affect your verdict with respect to another. Likewise, you must not let your verdict as to aggravating factors in one count affect your verdict as to aggravating factors in the other.
Yes, you just repeated that, I think.
Well,
you did. Said it twice.
Well, it says you must not let your verdict as to one aggravating factor affect your verdict with respect to another. Likewise, you must not let your verdict as to the aggravating factors in one count affect your verdict as to
so it's different.
Yeah, it's a little different. But
Okay.
It's basically the same.
What about as to mitigating circumstances?
Pardon me, Your Honor?
What about mitigating circumstances?
I think the mitigating circumstances are applicable to each. I don't think there's a delineation as to whether or not these factors.
It's so
we
quiet.
do that with regard to mitigating factors too, Judge, if you like.
I pointed out the one thing about mitigating circumstances regarding Ms. Ruiz necessarily wouldn't. I don't know if there's anything that would cause to be applied with count 1 with Christine Melton.
Well, obviously, the mitigating circumstances apply to both of them because it's not fact-oriented in relation to the guilt phase.
Most of them. The one that I think was delineated in there about Ms. Ruiz sounded fairly fact-specific. I think it was number 6.
It's very quiet right now. The tables, the attorneys are not mic'd.
So to the extent that you can, what I would like to do is the portions related to aggravating factors and mitigating circumstances, some type of heading as to count 1, Christine Melton, murder of Christine Melton, and then as to count 2, and then under each count I will read the instructions regarding aggravating factors and mitigating circumstances, and then I'll go to the next count and I'll do the same thing again, and that's consistent with the verdict form that you promulgated. And that language you were talking about from the general instructions about not applying your finding in one count as to the other, I think that should be somewhere in that transition between the two. And I believe that has been done in other cases in the circuit, where the court's read the instructions as to different victims.
Thanks, Karen. You beat me to it.
So I'm going to give you all a little time to do that, if necessary.
Judge, I appreciate a little guidance as related to the final instructions, Judge. The way, if I can direct the court's attention to the first page,
Okay.
I specifically delineated the aggravating factors alleged by the state as count 1, first-degree murder of Christine Melton R.
Right.
And then we have 1 through 4.
Right.
Okay? And then I've gone ahead and delineated the aggravating factors as related to Diane Ruiz.
Correct.
It's my understanding that Your Honor would like for me to go ahead and go so far as to go to the 4th page whereby we talk about the victim impact, specifically limit that to Christine Melton, apply
Yes.
that to the first aggravating factor.
Yeah, anywhere where you have, where it says Christine Melton and or Diana Ruiz, take that out and make it just specific to each victim.
Okay? And then, does the court wish to read all of the paragraphs all the way through to the bottom of the mitigating circumstances as it relates to Christine Melton, and then...
Yeah, it would go all the way to weighing the evidence.
Okay. Yeah. Okay. So, all right, I understand what you're saying now. So you want to go ahead and read all of that, all the way to the weighing the evidence, and then circle back around to the aggravating factors as it relates to Diane Ruiz.
Right.
And then read through all of that once again.
Yes.
Gotcha.
And then make sure, and you all can converse, if you want to include the mitigating circumstance as to Diana Ruiz in the instruction regarding Christine Melton. I don't know that you're limited to that. I don't know if you want to do that, but I'd listen.
Well, we're reading the block of mitigating circumstance instructions for each of the...
That's fine.
So that's fine.
That's fine. If that's what you want to do, I don't mind reading it. And
Let's do it that way.
Okay.
Avoid one other issue later on.
Okay.
Okay, while they get this sorted out,
all right. Well,
Dog Lover, do you have a business YouTube account?
Somewhere in between the
Some
two,
accounts
I
can't
think
get
you ought to
this.
have. Now, I'd listen to the defense on that as well. Did you have any questions or concerns or objections?
That makes a lot of sense. That's not in the standard.
But I believe it does accurately reflect the law, and the evidence supports that there are two separate counts.
I agree.
So, I mean, obviously, if you object to it, I'll listen to that as
No,
well.
I think that's appropriate.
Okay.
You're going to send the instruction back with them anyways, aren't you?
Yes, sir.
Okay.
Yes, sir. I just didn't want the jury to be confused about combining either aggravating factors or mitigating circumstances between the two counts. Because that is how it is set up on the verdict form as well. So I believe the verdict form is in proper form. If this changes, my changes and the instructions change anything regarding the verdict form, let me know. But I think it was correct.
Does he have a little bead tied in his beard? Occasionally, from some angles, it looks like he's.
So I can take a recess for
gold thing.
15, 20 minutes and let you all kind of redo that and see where you are.
I'll have this done in 5 minutes.
Okay. Why don't we take a recess then
5 minutes.
for about 15 minutes? We'll come back. Do you have any other questions before I go?
No, sir.
Okay.
Don't screw it up. Don't screw it up. Okay, so we've got a little bit of a break. Let's see. His long legs and short torso. He's wearing some sort of restraint device that is bulky, just below like his lower back. So I think that makes it so it's very difficult or uncomfortable to sit back on the chair. So the only position he can really get any sort of back support in is that slouched position. So I think that's caused by the restraint device he's wearing. It's quiet. Look at this. Let me see if I can show you. Super source. Give me a second. That's what it looks like. Doesn't matter which courtroom you're in, or just staring at the wall, or a fan. But little delays this morning. They happen all the time. This is the point in a trial where they have to get everything right before it goes to the jury, and so a lot of times the judge will make sure because a simple thing like oops, we screwed up the jury instructions, that can be a mistrial. You want to make sure you did them right. I don't know how much effort went into this. It seems like in the Wade Wilson trial, both sides agreed to the jury instructions just sort of early on, and now the judge made a ruling that the jury instructions need to sort of be separated out per charge. I think that's bad for Wade Wilson because if the jury instructions were read differently, it could have been construed to say that you have to find him that in both murders added together make him eligible for the death penalty. But now it's definitely going to be delineated out and show that he can receive the death penalty for one and not the other murder, which means it's just more likely for the jury to reach that conclusion, I think. Will he get his face finished if he gets the death penalty? I don't know if death penalty instantly means isolation, solitary confinement. I don't think it does. That's more something that's figured out based on the problems that he causes or his presence causes in the jail, and that's managed more on the jail level than what the judge would do. The judge isn't going to order solitary confinement. Even if he does get the death penalty, that will be years. There are years and years of appeals, and if he's able to get these tattoos in prison, he's probably going to be able to get more if he so chooses. Let's see. Is it going to be delineated even further to where they can now consider death penalty by the amount of product one puts in their hair? Steve, I don't think so. I don't think so. He is only about 30 years old. 30, 32, I forget exactly what his age was. But he's young and took 2 lives and threw his own away in the process. I don't think Wade Wilson's going to end in a mistrial, and for a couple of reasons. Possibly on appeal, but I just don't think his attorneys are on the ball enough to move for it when they should. I don't think they'll catch it. There were so many things that I think they should have and could have objected to during the state's closing. The rambling narrative, lecture style closing that we heard from the witnesses, that I don't think we can expect their objection game to be on point at this stage of the trial. It does seem sort of surreal to have trials coming to a conclusion today. Seems like we'd be with Karen Reed for another month. Do you have a copy of the mugshot before? Yes, I do. Let's see who sent that to me. My burner phone was so slow. It takes like 20 seconds to load each person's messages. I don't have a good way of searching for it. I don't remember where it is. But basically, before incarceration, he had up to neck tattooed, and after, the face tattoos followed. Next trial you're covering, I believe it's going to be Black Swan. Ashley Benefield which should be in jury selection right now. Might have to do a little catch up on that one. Depends on how long it takes. Yes, the charges that Wade Wilson's facing: 1 count first-degree murder, 2 second grand theft auto, 3 is battery, 4 is first-degree murder, 5 is burglary of a dwelling, and 6 is theft of a sandwich and a few White Claws. It sort of feels like we caught the guy who stole 6 cars and went on a rampage crashing through the town, and we're charging him for speeding as well as everything else. It just seems like why they threw that on there, unless it's an aggravating factor. You stole a sandwich during the burglary of a dwelling. I don't know why we did that, but. Trial starting in Tennessee today. What were the details of that one? We've probably heard about it, but he's the Hamburglar. I can't put down this gavel. I've been spinning it for nearly 24 hours now. I need a fidget toy. This is going to break something if I drop it. Oh, man. Slow start this morning. It is a cool gavel. Check. Look at this. Not sure if you can read that. There we go. We need the angle right. So it says Recovery Addict, Court of Public Opinion, established 2022. Everyone's going to send me a fidget toy now. I'm gonna put it away so I don't play with it, because I'm gonna either make noise or something else. Let's see. I did a quick check while we were sitting here waiting. Sarah Boone, still no updates. What we're waiting for, we did read her letter, her 58-page letter, which I found there was a ton of interest in. I was thinking for some reason that her letters over time would get less and less interest because they seem to be somewhat repetitive. But we read that letter, and it's been viewed. It's one of my most viewed videos in the last, I don't know, 6 months. So there's obviously a ton of interest in Sarah Boone, that case moving forward. We're waiting for the judge to set a date in her case to hear her attorney Cashman, her lawyer's motion to withdraw. That's going to be the first thing we hear. Then we have on 9/24, we have a pretrial management conference. If he doesn't allow her to withdraw, that will go, and that's basically a week or two before the trial that starts on 10/7. So, Misty Harris, today we're starting in Wade Wilson. We're waiting for a little motion right now. The attorneys were just putting the finishing touches on the jury instructions. Once those are done, the jury will be brought in. We'll hear either the jury instructions first and then closing arguments, or closing arguments and then the jury instructions. Either way, we're here for those live. Once the jury goes into deliberation, we anticipate that at that point, which will probably take about an hour or two from now, we anticipate going over and joining a little bit delayed the proceedings in the Karen Reed trial, which are expected to start about the same time, and those are the closing arguments, and so we'll stick and watch with those. Once Karen Reed goes in verdict watch, if everything works out perfectly, the times perfectly, at that point the jury will come back in the Wade Wilson trial with their verdict as far as the death penalty or life in prison, and then we will be just in verdict watch for Karen Reed. At that point, that is when we're going to jump over to Brandy Churchwell's channel and watch the verdict on Brandy Churchwell's channel, who, by the way, was 25 subscribers away from hitting 25,000 today, which is just amazing. She has grown a ton during this trial because she has put a ton of work, and everyone appreciates what she's doing on that. So good stuff. So we're excited to do that. It's going to be a good day, but everything has to work out. We can't have like a long delay in Wade Wilson and then. Yeah, everything, the schedules in my head, I put this together, so don't mess this up, courts, judges, attorneys. Either way, it's going to be an amazing day as we go through the proceedings here. I need to change things up. Let me. I need this to be Wade Wilson. Okay, so we're going to go from here to here. Let's see what the changes in the picture. Gets a little darker, but we'll live with that. And then I'm going to put Karen Reed over here. We're going to cover Alex Baldwin. I think we will. The hearing yesterday got a little spicy, which was in sharp contrast to the day before. I might even go back and watch the Alec Baldwin. If we have a down day as we're waiting for other trials to start, we might go back and watch some of that spicy hearing from yesterday. They had a gun expert sort of being interviewed, and I want to go back and hear exactly what happened there. But all right. My phone has stopped. This is Josh. My phone stopped telling me who sends the text. For some reason, the names don't match up anymore. Josh has sent us 2 mugshots, which we're going to set up for Wade Wilson, so we can give you a comparison in just 1 second. That was the wrong one. But we have a before and after mugshot I guess they're both befores. Maybe the one mugshot is from his who's out on parole or probation. He was on probation. Was that on bond? I forget. When he committed these murders, he had a pending case. Let's see, MacBook Pro. There's one. Get these ready for you. Just one second. Let's go right here. Okay, while we're waiting, let's oops, that's not the picture you want. Here's first mugshot right here. Lee County Sheriff's Office for that one. Thank you very much. You can see that he was not like a he was quite a looker. This may be his best picture, but prior to his tattoos, looked pretty good. Okay, let's go back. We're back.
Of the instructions. Okay. All right. We can go through those. Just take a look.
We'll cover the verdict after the fact, after I watch it live with Brandy Churchwell. Did I say we'll cover it live? We'll cover it after we watch it live. Judge is making sure everything's done correctly on the jury forms. Beth Gish, good afternoon to everyone. Woohoo, 16 months. Thank you, Beth. Wouldn't be the same without you here. Thank you. Appreciate the 16 months of support. Somebody's printing something. Andrew C. just noticed also having a membership anniversary. 14 months for Andrew. TA, I think he's sitting like that because on his lower back he has a some sort of restraint device that's underneath his suit coat. We've seen it as he's walked out several times. It probably juts out, I'd say maybe 6 inches from his back, which makes him sit a little farther forward. So the only way he can utilize the back of the chair is to sit in this position.
Okay. There's just a couple of edits that I see just off the top. There's a place on, well, first I want to put page numbers on this, I believe. The first, 4th page at the top, it is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances and need to be proven. I think you got to take the word "and" out. And then I believe that's repeated on, let's see, that's page 4, 5, 6, 7 to 8th page at the bottom. Let's see. The other part I would like to see is, I believe that I would like to see some of these instructions, like weighing the evidence, like started on a separate page. I don't think you can have them mixed in like that. Just put in a page break. So if it's a new title of an instruction, it should be started on a separate page. And if you want to email them to defense counsel in the court too.
feels like we're in the library. Just hear paper and books and copy machines. And
I hate to do this to you. The one thing though I didn't see on there was page numbers, and you're doing a great job adjusting to all these changes. But that way, if they get out of order, the jury can make sure that the pages are in the correct order. Bottom right corner. I was ready.
All right. Thal is proposing cruel and unusual punishments in chat. And no to all of them, by the way. Yes, I was ignored. It's quiet. You guys, I stayed up late. Okay, so I'm getting a little bit of rest while I can. Carol, happy birthday today. Happy birthday. We already sang the birthday song. I'm sorry we missed you on that part. We can add you tomorrow if you'd like. We can sing to you tomorrow. It's a fast printer. Every time it clicks, that's a page. 1, 2, 3, 4. That's really quick. It's screaming. It's not as fast as like a copy machine, but Dizzy Grenade. I'm in the UK and stayed up till almost 5 a.m. Watched your whole stream. Dizzy, that is awesome. Thank you so much. Love Pikachu there in your profile as well. Yeah, my printer would still be warming up and printing test pages. Does your printer do that? It prints like, it's like, hang on, we've detected you haven't used your printer in 24 hours, so we're going to re-warm up, recalibrate, and reprint test pages. And it prints like 50 test pages that are just black. And it's like all the toner. And then it's like, it appears you're low on toner. It's like, you think? You just used all of it. How do you turn that off? We will sing to you tomorrow, Carol, but the party starts today. Happy birthday. My printer is probably, it's like 15 years old.
I think we're gonna, if it's okay, take the numbers off the verdict form, page numbers.
The what?
The page numbers off the verdict form.
Oh, why?
Just because we can leave them on if you'd like.
Judge, like, I want
It
page
doesn't
numbers.
make any difference. Just leave it on. It does.
Okay.
If it needs to be off, I don't mind, but if it doesn't need to be off, then you could number the verdict form separately if you wanted. So you have page 1 through 4 of the verdict form. That'll change the other numbers.
This is nice. It's nice and calming. Dog Lover, how long do you think we'll be on this case before we go to Karen Reed's case? I anticipate that we will start Karen Reed's closings before they finish giving them. Does that make sense? There are going to be 2 hours of closings at least in Karen Reed's trial. They're still looking at the ceiling fan. I mean, Karen Reed has not started yet for the morning. So they're still doing work, probably the same sort of work that's going on right here with the jury instructions. But ideally, if everything works out, we're going to watch the closings here, which will be fairly brief.
Okay, so on the verdict form, I do
and
see
then start
where,
Karen Reed's a little delayed.
as for some of the jury recommendations, it carries over onto the next page. It's split up. I think they need to be together on the same page in terms of, I think, number 4, it's split up on page 3 as far as aggravating factors.
This is the state's first case. They don't seem to be very ready. We will say that we're going to follow Wade Wilson live here. We will be back. We will get you caught up. Well, we're going to get you caught up on the closings while they're deliberating in the Boston Canton case. So please don't put spoilers in chat. If you see something, if you're watching both, that's great. Just don't tell us what's happening in the other one. A lot of us would like to experience it the first time for ourselves, just like you do. So we don't want spoilers. I'll authorize the mods to be quite generous with punishments as far as timeouts for people who do put spoilers. And if you don't think it's a spoiler, but it's about the trial, about something you saw, that's a spoiler. So if you're about to share something from Karen Reed, Pamela, I'm just telling you, that's a spoiler. So, yeah, no spoilers. Don't. If it's about Karen Reed, unless we're watching Karen Reed, don't put it in chat. Is that cool? Is that fair? Never again, I pinky promise. There we go. That's good. Pamela, I didn't mean to call you out by name. I'm sorry. That was you were just the last of a long list of people who had done them. So I apologize. It was not fair of me. Shame. I still need the shame on you soundbite. I have not put that in yet. Shame on you, and you can't ignore the science. Air cannons are so much fun. It's like a t-shirt launcher. There's a lot of badges on that guy's shirt. Have you ever played with the t-shirt launchers? It's like a modified paintball gun with a much bigger barrel.
Okay. So what I'm saying is the courts, there's language in court cases regarding like splitting up, like this number 4 on the bottom of page 1 carries over onto page 2, and it should be all on one page. So either push it to the next page and then make sure that if, in other words, you don't want to have one run over from one page to the other. Okay.
Being problematic.
All right. I can get you more paper if you need it. I will want, once you get that done, just a complete printout of the final instructions.
Yeah, once it's all done, he'll want the font changed, and that will change all the spacing. I will tell you, Dizzy, these are lawyers. They're very good at what they do. What they do not do is format documents very well. They make arguments. I do notice that the defense team has sort of shuffled their positioning, so the mitigation specialist is no longer sitting next to Mr. Wilson. There's the rare under chin shot. Did you see? That's the only time we get to see what it says on his chin. No, that was not canoodling. He was, I think he was whispering to his lawyer.
They don't all have to be on the same page. You just can't have it split in half between two pages. Okay, so I mean, I don't expect you to change the font or anything.
Okay, so you're okay with.
You say that now.
Count 1, you're okay with 1 through 3 on one page, and then 4 on
4 would start next. It was just split between the two pages, and I think that court cases say that's not preferred. So. All right.
About time. Wait for the collating. Now that we've got our one copy, let's copy and make a copy for each jury, each of the jurors. This is why you have legal assistance.
Is there an instruction on the verdict that goes before the verdict form? No?
No, Your Honor.
Okay.
That's all delineated within the course of the death penalty instructions themselves.
I'm sorry, I can't hear you.
I said that's all been delineated in the death penalty instructions themselves.
Okay.
attorney's like mimicking his positioning, which is funny. The jury's not in the room yet. As soon as the judge gets all this sorted out, the jury's going to be invited in. And the judge just keeps finding problems with this. Okay, we are going to time out spoilers. If you get timed out, you gave a spoiler.
Okay. And did you email that?
I just want to make sure that the
Oh,
computer can make sure.
well, that way I can, if I see something too, maybe I can change it and print it. I don't want you to run out of paper. So.
I've got a whole ream over here, Judge.
All right.
Got a spare ream of paper to go through this morning. This does seem like it's been the longest portion of the trial so far. From what we've heard from people who've been on the inside, though, even a day in court is preferable to sitting in the cell. So this is a good reprieve. Just know that he is convicted at this point. He is guilty in the eyes of the law. So this is a day out.
Was it sent? Okay. Oh, there it is. I got it.
Keep clicking refresh. think right to speedy trial should apply here at some point. It's got to kick in. Thank you, Samantha. Please, to prevent being timed out, take the safe route and don't discuss anything related to the current event in the Karen Reed trial. We'll get there eventually and share the moment together. Thank you. New high score. Who actually misses the sound of a dot matrix printer? Do you guys remember that? How many of you guys bought paper, like green bar paper? Tractor fed. It was always straight. But you'd print and then just tear off a sheet. And if the best part was when you got it to line up properly so that when it finished printing, it would stop at the right point and you could just tear and it would tear along the dots. Used to make birthday banners. That's the only thing it was good for. Yes. Made paper springs out of the holes on the side. Mm-hmm. What's your record for how long you made one? The print shop. Oh, yes, the print shop. The judge just passed the last level of Minesweeper. He's secretly quite pleased with himself, entering his name for the high score right now. Judge Nick, a.k.a. Bomb Sniffer. Enter. Why'd we go quiet? Don't you have a talkie picture show anymore? We continue to wait. We are waiting.
Printed out. All I did in changing the last few things was just make sure that there weren't paragraphs split between one page or the other. So take a look and see if you all agree with those.
Just say
I'll
yes.
print out another copy too. Give that one to the defense. I'll print another copy for the state.
Clearly, the judge doesn't pay for his own paper. Judge finally
I'll need
just
that one
fixed it
back though
himself.
because that has the jury or the verdict form in it.
I wonder if he's at the verdict, if he's going to show any emotion. I mean, we already know they've found him guilty, and this was basically his response to the guilty verdict.
That's in state. And if you could also email me the verdict form too. Oh, you did? Okay, thank you.
I'm thinking there's a bracket somewhere that needs to be deleted. He's gonna fake tough guy it out. Calling it now.
I don't think so. No, I just got the instruction.
You didn't email it. You can't lie to the judge. You're an officer of the court. Did you email it or did you not email it? He is on lithium. I believe he is on medications that could explain some of his behavior in court. Here goes the printer again. We're going to do one last round of printouts for everybody just to make sure you have the latest and greatest. And then how many people are in the audience here in court? Let's give them each one as well.
Any, I'll let you finish going through them.
Did he? What are his
From the
socks?
defense side, any objections to the final draft?
Can we approach the bench?
Okay.
He has like graphics on his socks. They have complaints still. You have problems with the jury form now? Cameron still has not learned to adjust the pan and tilt speed adjustment on these cameras. Interesting. This courtroom also is equipped with the mute device the judge uses is a decibel mute only. It's not a feed mute. What that means is it turns down the audio a set amount, which it believes should be enough to make it all the way quiet. But there's still audio there. There's enough that I can hear it, and if need be, I could turn it on and hear what the judge is saying. But the way the microphone picks up, it's only pointed at the judge. So we would not get everything. We'd only hear the judge as part of the benches. Love that job. Love that job. Judge is leaning over towards the printer. Looks like he's printing it one more time. All right, there's the printer sound. Are we ready now? It looked to me like the attorney was saying something about... No, never mind. I was going to make a joke that's probably not appropriate. I won't go there. She's like, what are you doing? Quit sniffing my shoulder. Oh, they're talking behind her back. Literally, they're talking behind her back. How rude. His life sentence will be over by the time this closing start. Is he Peter Griffin?
All right, let's go through the headings of each then. I'll just make sure on the record whether the state or defense has any objections to the final instructions. So I'll start with final instructions and penalty phase, page 1. Any objections?
No.
State, any objections? No. Okay. Page 2.
No.
Page 3.
No, you're right.
Page 4.
No, you're right.
Page 5.
No, you're right.
Page 6.
No, you're right.
Page 7.
No, you're right. Judge, on page 6, subject to my previous objection, page 4, I'm sorry.
Sorry, page. On page 6, okay.
No, on page 4.
Page 4.
We discussed it.
The previous objection noted for the record.
Yes,
Okay.
so in there one more time, so.
That's fine. And I overrule the objection based on the
Yes, sir.
promulgated standard instructions from the Supreme Court. All right, so then
We were on
page
six.
5, let's go back to, so page 4, I noted the objection. Page 5, any objection?
No,
Page 6, any objection?
no,
Page 7.
no objection.
There.
Page 8.
No objection.
Okay. Page 9.
No objection.
Page 10.
This same objection we had before.
Same objection noted and overruled for the same reasons.
With the exception of that, no objection.
Okay. Page 11.
No objection.
Page 12.
No objection.
Page 13.
At least he's not reading everything.
Page 14.
No objection.
Page 15.
No objection.
Page 16.
No objection.
Page 17.
No objection.
Verdict form, page 1.
No objection.
Verdict form, page 2.
No objection.
Verdict form, page 3.
No objection.
And verdict form, page 4.
No objection.
Submitting case to the jury, page 18.
No objection.
And page 19.
No objection.
Very well. All right. Okay. Now, are we ready to? I know you all probably need a quick break, and then we can start opening arguments. Or not opening arguments. I apologize. Closing arguments. Is that correct?
Another break.
I know. I think somebody requested a quick break, and then we can start. Is that correct?
Yes, sir.
Okay. So let's just take like a 5-minute break, and we'll start with closing arguments.
It's 10:41. We've been going for nearly 2 hours. See, look at that thing he's got on his back. Do you see that? Just got a water delivery. There we go. I think we've got everything out of the way now, so we're ready to proceed with closing arguments in just a couple minutes. So from this point on today, it's probably going to be quite busy. We're going to have first either jury instructions read or closing arguments. I think it sounds like we're doing closing arguments first. Just depends what the judge decides to do. Then we've got, let's see. Then we're going to jump over to the Karen Reed trial and follow that. Evil Queen, I've got to time you out. I'm not sure if you don't know, you're typing in our chat about Karen Reed, and you're probably watching both and you're in the wrong chat. We're going to time you out just for a minute till you can catch on. We're not doing any spoilers in this one. Let me get that here. And first time out's for 10 minutes. All right. Where's your mug? The mugs, I think, are in the dishwasher. But I'll be okay. No Mountain Dew. I'm so stinking proud of myself. I have to tell you, I've been eating way too much salad and drinking zero Mountain Dew for a long time. And it's paying off. Let's see. Let me do the math. Not here to brag. First of all, I'm ashamed at what my weight was to start with, so I'm not going to share that. So I'm down over 15 pounds. And in a month-ish. Yay. That's it. And I only have to lose like another 12 pounds to be my goal for my trip. I feel better too, which is great. Yes, party, we'll celebrate. Woohoo! Does that make you a goat? thought the battery was dead for a minute. I actually enjoy salad. As a kid, I used to eat salad just by choice. Of course, I used it it looked more like soup based on how much ranch dressing I put on it. But it was really good. Stay focused. Stay focused. Yes. Okay, a couple more minutes. We're going to start with Wade Wilson. I think this is going to be a quick one. Both on, let's see, the dressing of choice. I chose Italian because it seemed a little bit healthier than ranch. I like them both. I like everything but blue cheese. It seemed healthy, and it's something I can buy in bulk at Sam's Club, which I like to do. So I got the Olive Garden Italian, and I try to go light on it. But that's my indulgence. I know the dressing is where all the calories and everything are, but that's what I do. How's the lawnmower going? Still early. I've got to replace a vacuum hose. I think it's called a vacuum hose, to see if that fixes it, but I don't know. I am so far beyond making my own anything. I even buy my salad pre-cut. I don't have time to make it. Lee, I agree. It's really good. I have not used diet dressing. I go full flavor. I figure if I'm going to eat healthy, I want it to taste good. That's my compromise. If all else fails, fix the mower, then you have all the greens you can eat. John, it actually rained. We've been having a bit of a drought. They call it a drought in North Carolina when it doesn't rain for 2 weeks. And it hadn't rained for about 2 weeks. So everyone's yard was dying. It's terrible because nobody has sprinklers around here. There's plenty of water that falls from the sky to keep everything in your yard alive. And last night, the storm that came through dumped like 2 inches of rain, just all at once. And everything has just turned green again overnight. It's amazing. And now my lawn is about 2 feet tall. Giving up soda is hard. It is. Especially hard. I love sodas while I'm driving. Basically, it keeps me awake. And that's been my go-to. I used to drive a lot for work. I used to drive 3,500 miles a month, which I think is a lot. I used to drive a ton, and it was a soda. Every time you stopped at the gas station, you got the soda. You got a fresh cold drink. It was a habit I got into. So now I get to go across the country without one. We'll see how that goes. Am I exercising? I'm exercising my mind, Pickles and Zoe. I am trying to do a little bit more on the weekends, getting out and about, doing metal detecting, doing a little walking. But that's about it. All right, we're ready for this break to be over, Judge. If you can come back in and call things to order, let's kick things off. It's been a long day. We have to get caught up with Karen Reed as well. So, Reverend Beasy, thank you. You inspire me by running a half marathon while I'm sitting on my butt in my lazy chair every day. But I don't think I'm ever going to be at that point. But I just want to start feeling good again. 2K is a ton. So 3,500 is well over a ton. For me, the big thing, the bigger problem was I just enjoy eating. Like, the act of eating is enjoyable for me. And so when I was bored, that was something that would be an option. I could eat because I was bored. I also needed to work on portion control, because when food is good, it's like, wow, that's good. I want some more. Yeah, I do, but I'm not hungry. Or if I really listen to my body, I don't need any more. So that's been the most beneficial. I think the first few pounds for me are easier to lose, but after that, I really need to start exercise and doing some more work. It's gonna be harder going forward. I think it doesn't just continue to fall off. Portion control. What is this? Well, Steve, it goes like this. Everything you buy, from water to a big party bag size of chips, is a single serve portion. So buy smaller bags. That's how it works. Reverend's about to go on the run. Amazing. Braxton, enjoy your meeting. Have fun. We're going to be kicking things off here, and before it starts, let me ask this: should we separate Wade Wilson and Karen Reed into should we portal between them? It would be cleaner on the replay. I can set it all up right now if we want to. We could portal over and then watch Karen Reed. The only problem is the verdict in Wade Wilson will probably come back very quickly. Because it doesn't have huge international media attention. Yeah, let's portal. Okay, I'll get that set up here during the break. So we've got Wade Wilson right now. All right. We're set up. I've got an unlisted video to jump to redirect to for the closing arguments in Karen Reed, which we're going to go to as soon as the closing arguments are done, and we're in verdict watch for Wade Wilson. That's our plan today, so we're just going to be a little bit behind, but we should complete the closing arguments in the Karen Reed trial before the jury is able to reach a verdict in that trial. And so we should be up to speed. That will allow us to watch live the Wade Wilson verdict, which I think will come back very quickly. And Greeners is like, challenge accepted. And then we'll be live in Brandy's channel for the verdict here, and then we'll come back here and do another. I could use Telemark Media for one of the feeds. Don't want to do it that way right now. Until I need another ME. I need another switcher set up to run that channel the way I want to, just because the audio routing, I only have one way to route audio, even though I can route video to places. I need to be able to control the audio separately. So I need basically another switchboard, which is all in the plan. We'll get there eventually. Okay, the 5-minute break is taking more than 5 minutes. Is there ever a quick verdict on not guilty? Wasn't there one time where they granted the judgment of acquittal? Or did I dream that? So far, I haven't been sharing my specific weight progress on my diet plan, other than what you've heard. But I do have an app on my phone that tracks it. My scale is a Bluetooth scale. Here we go. Finally.
You can be seated. It's fine.
The jury's here, and then they brought in the defendant?
All right, let the record reflect. State's present, defense counsel, the defendant are all present. Are we ready to proceed with closing arguments?
Yes, Your Honor.
I guess the jury's not there.
Okay. And I presume any objection to me reading the closing argument instruction? The structure is the same, I believe, correct? Any objection to that? I'm sorry?
So we don't get a rebuttal, but I don't think it states that in the...
Okay. So let's see. I would just say the attorneys now will present their, both state and defendant have now rested their case. The attorneys now will present their final arguments. Please remember what the attorneys say is not evidence or instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Just end right there.
That's fine.
No objection to that. All right. Let's bring out the jurors.
You will bring the jury.
Once the jury's here, this should go a lot faster, because we've smoothed out all the details to this point. And Tracy, congratulations in advance. Hope everything goes well for the baby and mom and dad and you. That's really, really cool. If you have to suddenly run and leave us, I would understand. Oh, we'll save your seat if you run. If you have to run. Boogity boogity. I can't do this. Boogity 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 boogity. Let's go. Those syllables are hard to make. Welcome to Jumanji.
Please be seated. All right, ladies and gentlemen of the jury, welcome back. By a show of hands, was there anyone on the jury who was not able to follow the court's previous instructions about doing any research, looking up anything, or discussing anything about your service as a juror on the case? Seeing no hands, we're ready to proceed. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case.
May it please the court, counsel. Ladies and gentlemen of the jury, this is the point in the trial where we are going to do what we told you we would do when we talked to you individually on that first day you reported for your jury service. This is a point of the trial where we make that big ask. The point where we ask for your recommendation of death in this case. We do not take this ask lightly. We are not flippant. We are not naive. We are not ignorant of the fact that this ask is one that will literally alter the course of Wade Wilson's life. But before we make that ask of you, that ask of the ultimate punishment, I want to go through the evidence, the aggravators and the mitigators, and to remind you why this case is different from others. Why these murders are aggravated and how they stand out from other cases. And as we talked about on that first day of jury selection, there are only certain cases where the state can even seek death, or as the defense said, special cases. An aggravating factor is the only circumstance under Florida law that could result in a defendant receiving the death penalty. And there must be one aggravating factor for each for the state to seek death. And the notice we filed has 4 aggravators. 4 aggravators for the death of Christine Melton and 4 aggravators for the death of Diane Ruiz. And the state only has to prove 1 to ask for a recommendation of death for each. I'm not going to go through each aggravator at length because my colleague did that in his opening statement, where he reminded you of the details that came out on the trial. And you can review any of that evidence. You can rely on your notes and what you heard in the trial to make your decision about the aggravating factors. But I want to start briefly and go through the aggravators and how we've proved them. Let's start with a capital felony was a homicide that was committed in cold, calculated, and a premeditated manner without any pretense of moral or legal justification. You already found beyond a reasonable doubt that the murders were premeditated through your verdict. You found 2 counts of first-degree premeditated murder. You must now find that that premeditation was heightened, demonstrated by a substantial period of reflection. In order to do that, I think it's important to start at the beginning of this case, where it all happened, off McGregor Boulevard near College Parkway at the Buddha Lounge. Music was playing, people were socializing. The defendant went there to have a good time. And he discarded the woman he came with, and he chose one that caught his eye, Christine Melton. And as he told detectives, this is what I do with women, you know. I use my charm, I use my good looks. That's what I did with the first girl, and that's how I got in her head. And look what happened to her. When the defendant first approaches Christine, he's not threatening. He's smooth, he's charming. He's nice to her and her friend Stephanie. They party together, no red flags, no sign of aggression. He's a fun guy, but he waits. He waits until he's back at her house, in her bed, and Stephanie has gone home. He waits until he is alone with her, until there are no other witnesses. He waits until she is asleep, defenseless. The defendant says she can't get away from him, even if she wanted to, because he's too strong. And when she can't get away is when he kills her, when he strangles her, because he was the lion and she was the prey. But he didn't stop there. He was looking for more prey. He found Diane Ruiz walking in Cape Coral and said, "That's the one. You know what? I've already done it once, and I'm going to do it again." He knew there was a school, but he wasn't worried about the school. He wasn't worried that it was daytime, because he got her into his car. He got her alone, and that's when he attacked. He decided he was going to kill her when he saw her walking, and he already knew that he was not going to let her go. He could tell she was getting scared, and he saw her fear. He knew Diane wanted out of that car bad and that she was afraid. He could sense her fear, but what was he? He was the lion, and she was her prey. He had a careful plan. He didn't murder Christine or Diane in front of people. He gained trust. He selected Christine at the Buddha, and he selected Diane as she was walking. He secluded Christine in her own home, and he secluded Diane in the car. And then he tortured and strangled them both. He used calm and cool reflection. He waited to kill Christine. He waited after they had left Jason's home. He waited all night into the early morning hours. after Stephanie had gone home. And that's when he killed her, not in the heat of passion, but when she had gone to sleep. He waited for Diane. He waited until he saw the right person. He waited until she was in the car. He waited to reach out and choke her. This wasn't a lover's quarrel. There was no fight. He was calm and he used cool reflection. The way in which he killed both Christine and Diane was in a cold, calculated, and premeditated manner. The second aggravator is that the capital felony was especially heinous, atrocious, and cruel. The jury instructions define heinous, atrocious, and cruel, and it states that the murder is one which is accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Christine Melton or Diane Ruiz. Strangulation alone is heinous, atrocious, and cruel. Why? Because the victim is aware she is going to die. The victim knows what is about to happen as that perpetrator's hands are wrapped around her neck. And the force that must be used to kill with his hands was significant. Christine Melton was woken out of her sleep. The person she had just partied with, the person she was intimate with, the person that had built her trust, the person she had led into her home, into her bed, had his hands around her neck. But before he killed her, he inflicted torture. He inflicted pain, and he showed utter indifference to her life. We know she suffered before she died because there is evidence she tried to fight him. Her fingernails were broken, her brain was swollen, and the swelling occurred from blunt force trauma that the defendant inflicted on her before she died. She was covered in bruises. She was bruised on the outside of her body. She was bruised on the inside of her body. She had bruising of numerous internal organs. She had hemorrhaging and bleeding on the outside of her body and hemorrhaging and bleeding on the inside of her body. She had injuries to her head and to her brain. The defendant seemed to enjoy the fact that she suffered, and he told his dad such things. For Diane Ruiz, he pulled her into his car and beat her. He broke her nose. He grabbed her by the neck, choking her, strangling her. He pressed so hard that he broke her hyoid bone and broke her thyroid cartilage. And like Christine, we know too that she fought back. Diane had defensive wounds. She had bruising on her left forearm and the back of her hand. And the defendant said when talking to law enforcement, she was a fighter. I'll give her that. And as he choked and strangled her, applying far greater than 10 to 15 pounds of pressure, she came back to life 3 or 4 times. And as he drove through Cape Coral trying to find a place to deposit her body, she was still alive. And when he pushed her out of that car and she got back up, what did he do? He ran over her. He said he ran over and over her, making her look like spaghetti. She had a laceration under her breast. She had hemorrhaging in the back of the neck, on the spine, and all around the vertebrae of the bones of her spine. And the significance of that hemorrhaging is that there was a significant force that went through that region while she was still alive. And Dr. Coyne is the one that testified to that. Because if she was already dead, there would not have been hemorrhaging in those areas. She knew her attacker was the defendant. She was conscious of her attacker. She was conscious of the beating. And most importantly, she was conscious of her impending death. Not only did she feel pain, ladies and gentlemen, but she was afraid. The defendant testified that he saw her fear, but he wasn't about to let her go. He was going to, and he did inflict a high degree of pain with utter indifference to Diane's suffering. The way in which the defendant killed both of these women was extremely and outrageously wicked and shockingly evil and vile. Both murders were especially heinous, atrocious, and cruel. The third aggravating factor is that the defendant was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. He didn't just kill one woman, he killed two. Two innocent victims, one trying to go out and have a good time, and another just trying to get to work. And the defense conceded in their opening that the state had already proven this aggravator beyond a reasonable doubt. The fourth and final aggravator for each of these victims is that the capital felony was committed by a person previously convicted of a felony and under sentence of imprisonment or placed on community control or a felony probation. You heard from Lisa Lansky, the print examiner, who compared his prints from being sentenced and being placed on probation to the prints that were rolled in court, and they were one and the same. And you also have the certified records and evidence showing that he was on probation at the time of these murders. And the defense in their opening conceded to this aggravator as well. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent to every first-degree murder. The state has met our burden, and we've shown you how we have proven the aggravating factors beyond a reasonable doubt. We have proven that this first-degree murder case is an aggravated one. And it's one so aggravated that the legislature has laid out the law that death is an appropriate penalty given the nature and circumstances of these murders. The defendant chose his victims and acted in a way that shocks the conscience of any human who hears the facts and sees the evidence that you saw and heard in this case. The defense presented mitigation during this phase. Anything can be considered mitigating, and you're to consider each of these mitigators. Unlike aggravators, however, where the state's limited by statute, the defense is not limited. However, each of you individually get to decide how much weight, if any, to give to these factors. So I want to go through some of them. And you'll hear, when the judge reads the jury instructions, you'll hear all of the mitigators that they've listed. But I want to go through some of the main ones. Let's start, however, with the expert testimony. You heard from Dr. Mills. He testifies solely for the defense in capital cases. And he said on the stand, I was hired to try to help him. Not to give an objective opinion, not to conduct testing and to try to find out if he suffers from a mental disorder, but yet he was hired to try to help him. And the only people he helps are defendants. He only works for defense. His testing that he was able to accomplish, the MMPI and the PAI, were invalid because of the defendant's exaggeration. And once those tests were invalid, the defendant refused to meet with him again, refused to provide any additional data. And what was interesting about Dr. Mills is that he discounted the records in front of his face, the evidence that he had before him. He did very little review of the records. And in fact, when I asked him, initially he had said he hadn't reviewed those records. And then on the stand, he said he did review the records. But when I asked who these people were, he couldn't remember. But he gave credence to records that don't exist. He said the hundreds of pages of jail records were basically useless. Yet he relied on the mom's report, which was extremely limited, with no supporting documentation. There was only one evidence of a Baker Act in 30 years. And the Baker Act was because his dad found drugs. And he was released from the facility the very next day. And when I asked him, isn't that unusual, doctor, for someone who supposedly has schizophrenia or some major psychotic disorder to be released the next day? He couldn't say yes. He said, well, maybe his parents don't really remember. Don't you think his parents would remember that if their son was in a mental hospital for an extended period of time? So he doesn't give credence to the Baker Act. To that report, he can't really rely on it, but he's going to rely on other vague things that the parents tell him. He tries to build a diagnosis on two things the parents told him. That there was someone in the garage on one occasion and that people were looking through the windows. That's the basis of this doctor's diagnosis. He also tries to give credence to there being a major mental health issue and try to say that that mental health issue came first. But when do those changes in the defendant occur? When he's 13. And when do his parents notice these major changes? When he's 13. And what did the defendant tell the investigator? That he began heavy drug usage and got into drugs when he was 13. Yet Dr. Mills discounts the defendant's own admissions and the reason for the Baker Act because they don't fit the narrative of a psychotic disorder. They fit the narrative of substance abuse problems. He discounts the school records. He discounts that the defendant was kicked out of school for selling drugs, not for psychotic episodes. And the defendant also admits that he was kicked out of school for selling drugs to his own investigator. And we had a conversation both with him and with the state's expert about the DSM-5 TR. And it clearly states in there that drug use must be ruled out to make a diagnosis. And that you can't diagnose a psychotic disorder under the circumstances in which Dr. Mills did because he could not rule out drug use. Nowhere in the records could he find the criteria laid out to support the diagnosis of a psychotic disorder. He had 13 years of medical and mental health records, and there was no specific instances of hallucinations and no specific instances of delusions and no diagnosis of schizophrenia. And these are some of the things that were required to make such a diagnosis. And the only drug he was prescribed through all these years up until 2022 was for depression, Celexa. And both doctors came up in their SIR rebuttal after Dr. Herkov testified and listed out for you a bunch of medications that could potentially be used to treat a psychotic disorder. But the problem? They weren't prescribed until 2022. And again, nowhere in the records was he even given a diagnosis of a psychotic disorder, not even in 2022. And I asked the doctors if they had reviewed the emails where the defendant was trying to find out more about drugs and that drug addicts are often med-seeking. They hadn't reviewed those emails. The family's recantation of paranoia and of him believing people are watching him can't be attributed to a mental health disorder because by the defendant's own admission, he's on drugs, which also is a cause of hallucinations and delusions. Here's a doctor who can't gain cooperation or get information from the defendant, yet he chooses to essentially ignore the case documents. He doesn't review the videos. He doesn't review the tangible evidence from the case. Because the problem is, the evidence that you heard and saw in this case do not support a diagnosis of a psychotic disorder. And he has to downplay the jail records because they also don't support the diagnosis of a psychotic disorder. You also heard from Dr. Hyman Eisenstein. Now, his background was very limited. He only worked for a rehabilitation hospital for a year, and then he started doing contract work. And in his contract work, he, in the 80s, got involved in a death penalty case and decided that was what was going to become his specialty. And he said that he's testified in over 150 capital cases. How many for the state? None. All on behalf of the defense. And what is a diagnosis in almost all 150 cases? The same. Imagine that. Prefrontal lobe damage. Now, unlike Dr. Mills, Dr. Eisenstein actually spent a lot of time with the defendant. And during that time, he saw no evidence of psychosis, no evidence of delusions, no evidence of hallucinations. And when the defendant reported about mental health issues, it was all in vague generalities. Dr. Eisenstein didn't ask details. And when I asked him, well, what was he hallucinating? What were delusions? He didn't know. He didn't ask because guess what? He was just there to test his brain, to see if his prefrontal lobe cortex was working, which we already knew was not going to be given his testimony that he gives in all of these cases. He also kept saying during the defense direct examination that, oh, the defendant had all kinds of diagnoses, all these diagnoses. And when I asked him where in the records he found any kind of evidence of schizophrenia, he said, oh, I misspoke. I didn't find evidence of that. And the problem is his testing didn't say what he wanted it to say, what he tried to make it say to you. He said that this guy scored in the 2nd percentile in regards to his memory. That means, as Dr. Herkoff said, only one person in the line is behind him. That's how bad. Yet when you look at the case files and the videos and listen to the statements, there is no evidence of memory impairment. In fact, I would submit his memory is actually more than fine. There's also nowhere in the records that suggest his memory is impaired, which would be startling for a 30-year-old to have dementia or some major memory impairment. No signs in the records. And in fact, what do the records say? They say opposite. Dr. Herkoff found in the records where it said his memory was intact. His parents didn't indicate he had problems with memory, and the defendant didn't complain he had problems with memory. And when you see the doctor's own testing results up on the board that Dr. Herkoff showed you, his executive testing and front lobe testing didn't show any damage. Dr. Eisenstein didn't review the case records at all. He knows very little, if anything, about the facts surrounding the murders. And what does he do? Same thing as Dr. Mills. He discounts the records in front of his face and gives credence to records that simply don't exist. He states that the defendant had synergistic brain damage through all of the head trauma. And where does he get this information from? The defendant's father, who indicates he's had some bumps and bruises from playing sports, none of which landed him in the hospital, and none of which required any kind of treatment. And the 2 car accidents, the first one, no treatment, didn't go to the hospital, no follow-up care. And when he went to the hospital in the 2nd car accident, he had a CT scan, it was negative. There were no issues, no bleeding, no problems. The defense attorney, the expert, Dr. Eisenstein, tried to suggest that somehow taking a test is significant, that having a CT scan in and of itself is significant. That's like saying it's significant that if a woman takes 20 pregnancy tests and all are negative, that it means something. Taking a pregnancy test doesn't equal pregnancy.
Wonder how many
and
women are
having
on the
a
jury.
CT scan doesn't equal brain damage. In fact, all of the CT scans were of no significance. And his own sister, who's a radiologist, who's trained to read CT scans for a living, confirmed this information to Dr. Eisenstein. So some falls in 2 sports, and 2 car accidents, one in which he didn't even need treatment, led Dr. Eisenstein to the conclusion that the defendant suffers from synergistic head trauma. Again, he ignored the records in front of him and gave credence to records that don't exist. Now, Dr. Herkoff, the key difference with him is he works for both the state and the defense. He's not here to give an answer that we want him to give. He's here to review the records and to make a decision not based on emotions, but based on the DSM-5 TR. He used the records. He used the data. He reviewed the videos. He reviewed the defendant's statement. And what did he find? No cognitive impairment, no brain injury, and no criteria that meets a psychotic disorder. The majority of the records contain self-reports, the defendant telling staff his diagnosis, the defendant asking for specific medications, and throughout the records, what are the main complaints? Depression and anxiety, treated by Celexa. 2 likely problems for someone who is incarcerated. You're going to be given the weighing the evidence instruction, just like you were in the first portion of this trial. And it says expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like all other witnesses, you may believe or disbelieve all or any part of the expert's testimony. And I would suggest that these experts should not be given a lot of credence that the defense presented. You as jurors know more about this case than any doctor who evaluated Wade Wilson does. Neither of the defense experts read through the discovery or read through the witness statements, or very many of them. You are the ones who sat and listened to 28 witnesses. You're the ones that saw the evidence. You're the ones that held the pictures. You're the ones that know what happened in this case. You saw the body cam of the defendant and how he was acting after the murders. You heard his dad testify about how the defendant killed Christine Melton and Diane Ruiz. And you heard the defendant's statement to law enforcement confessing to the murders. It's not credible that mental illness caused the defendant to murder Christine Melton and Diane Ruiz. He was under the influence of power, of lust, of control, of hate. He showed utter disregard for women and for life. The reason for the defense's expert is because most of their mitigation revolves around mental illnesses and drug use. So let's talk about a few of those. The first is that Wade Wilson experienced the following mental health disorders: schizophrenia, schizoaffective disorder, delusional, paranoia, social adjustment disorders, hallucination, and preservation. Again, the evidence in this case points to the defendant being addicted to drugs and that his addiction was the source of his problems, not a serious mental illness like schizophrenia or schizoid affective disorder. Certainly he was depressed at times and anxious, but almost everything in his records are self-reported with very little evidence of symptoms that would support such a diagnosis. Another mitigator the defense has listed out is that while Wade Wilson was on drugs, he's out of his mind, on a rampage, makes him crazy, and makes him do wrong things. Contrary to what we see in this case, he was the life of the party that night. He was having a good time, talking to women, making his rounds around the Buddha, listening to music, drinking. He drove to the Buddha that night in an $80,000 car with his girlfriend. He ditched her and meets another girl. He picks her. He's not out of his mind. In fact, he says that 9 times out of 10, this works to get him what he wants. Girls fall for him. He chose Christine. And the only evidence of drug use from that night was a line or two of cocaine. He wasn't on a rampage. He was cold and calculated. Stephanie Johnson didn't see him acting out of the ordinary. She didn't see him out of his mind, on a rampage, acting crazy. Jason Shepard didn't see the defendant out of his mind, on a rampage, acting crazy. Stephanie left at 6 a.m. that morning. No red flags. Everything was fine. Checked in with Christine. You good? Yep, she was good. He did wrong things, all right, but he was and he is fully responsible. He knows what he was doing, and he thought about what he was doing. Another mitigator they list out is the drugs that Wade Wilson took that night before the event led to an unanticipated effect. The mitigator is virtually the same as the one I just went over. But don't let this mitigator be a suggestion of some other drug take away from what you know the facts to be. There's no evidence of him taking any drugs other than the cocaine prior to the murders. In fact, there's no evidence of him taking any drugs after the murders. You see how he parks his car at Mateo Graphics. He backs into the spot perfectly. You see, and you heard how he speaks with law enforcement. He engages with them. He denies the battery. And then when he realizes he's going to be detained, what does he do? He takes off. And then you also hear how he speaks to law enforcement 3 days later. He speaks the same way as he does to his father. Another mitigator the defense has listed is that Wade Wilson confessed to law enforcement to do the right thing. Ladies and gentlemen, there was no doing the right thing by this defendant. There was no evidence in that statement that you heard that showed any kind of remorse or desire to just help. There was nothing in his confession that he was doing it out of the goodness of his heart to help the police. He wanted a hamburger and fries. He mentioned that over and over. And he wanted to be in general population instead of isolated by himself. Another mitigator that the defense listed was that Wade Wilson tried to reach out to his biological parents when he became an adult. Why did he do that? He wanted money from his dad. Remember, his dad testified he always wanted something when he contacted him. It was always about the defendant, always what he wanted, what he could gain. That's what this whole case boils down to. It's about him. And why did he reach out to his dad again in this case? To hide him from law enforcement, to get him out of town. Many people, ladies and gentlemen, suffer from drug addiction, but they don't go out and commit murders. Many people suffer from mental illnesses, but they don't go out and commit murders. Many people are adopted, but they don't go out and commit murders. I would suggest that none of these mitigators explained what happened on October 7th of 2019, and that you should give them very little weight. So you are now at the point where you have heard and seen all the evidence of the state's aggravators and the mitigating circumstances presented by the defense. And if you all find that the state proved one aggravator and the defense a mitigator by the greater weight of the evidence, you must weigh whether those aggravating factors outweigh any mitigating circumstances that the defendant proved by a greater weight of the evidence. So what is it exactly that we're asking you to weigh?
Ooh, she's got props. She's got the glove.
We're asking you to weigh the curtain rod that was used as part of the torture, that has her blood on one end and Wade Wilson's DNA on the other. We're asking you to weigh how the defendant met Christine Melton, how she looked when he met her, with how he left her. We're asking you to weigh the large number of bruises to her body. We're asking you to weigh her swollen eye. We're asking you to weigh the cuts around her mouth and her eye. We're asking you to weigh the bruising all over her torso, the bruising all over her arms. We're asking you to weigh the blunt force trauma. We're asking you to weigh the significant hemorrhaging on both sides of her neck. We're asking you to weigh the bruising of her lungs, the bruising of her liver, the bruising of the back of her bladder, the bruising to her colon, the significant force to her abdomen. We're asking you to weigh the injuries around her scalp and around her head. We're asking you to weigh the swelling of her brain. We're asking you to weigh his hands around her neck, not being able to breathe, taking that last breath, knowing it would be her last. We're asking you to weigh the cold, calculated, and premeditated way in which he murdered Christine Melton. To weigh how he picked her out from all the ladies at the bar that night. How he flirted and got her to her house, waiting until no one was around, waiting until she was asleep, his hands around her neck, not being able to breathe. We're asking you to weigh the heinous and atrocious and cruel way in which she killed Diane Ruiz. Diane Ruiz, who was simply walking to work. How we met her and how he left her. We're asking you to weigh her fractured nasal bone, the laceration under her left breast. We're asking you to weigh the hemorrhaging and the skin on the left and right sides of her body. We're asking you to weigh the bruising on her left forearm and the back of her left hand, the bruising on her right arm and the fracture of her finger, We're asking you to weigh the hemorrhaging to her neck, her broken hyoid bone, her fractured thyroid, her fractured ribs, fighting her until she was dead. We're asking you to weigh him running her over with a car. We're asking you to weigh the cold, calculated, and premeditated way in which he murdered Diane Ruiz, picking her up while she's walking down the street, sensing fear, not letting her go, getting her into his car, secluding her. We're asking you to weigh the fact that he was on probation when he committed this crime, and to weigh the fact that he killed both of these women within hours of each other. We're asking you to weigh all of these things and any other facts you may have heard in this trial that support each of these aggravators to the very little mitigation in this case. This isn't about numbers, it's about weight. And what weighs more in this first-degree murder case? In these murders, in the murders of Christine Melton and Diane Ruiz, the aggravators are so much heavier, so much more than any mitigation presented by the defense. And so now is the time that we make that big ask. We ask that you make that hard decision, that you recommend the ultimate crime, punishment for the ultimate crime committed by this defendant. Christine Melton and Diane Ruiz on October 7th of 2019. Thank you.
Give it a minute, Mr. Shirley, let her get it back to the clerk. You may proceed.
Thank you, Your Honor. May it please the court, counsel. Wow, how do we even follow that up? We followed it up with truth. First of all, on behalf of myself, my colleagues, most of all, Mr. Wilson, thank you for your participation. That's probably not the right word. We're asking you to vote to save Mr. Wilson's life. That's a lot more than just participation. That's probably the worst dilemma you may have to face in your entire life as to whether or not you vote for life or you vote to recommend death for Wade Wilson. The judge started this off with an instruction, and I ask that you refresh that instruction in your mind. As counsel and I try and make our points, we may say things to you that differ from what you heard from the stand. We'll talk about that in more detail as it relates to Dr. Mills and some of the other doctors that testified. Nevertheless, you have to rely on your memory, on your notes, on the collective memory of each and every one of your fellow jurors, because you're going to have to go back there and deliberate, and you're going to have to discuss these things. Let me start with addressing the state's mitigating factors. We already told you the reason that they're factors and not circumstances is because they have to be proven beyond and to the exclusion of every reasonable doubt. Well, the problem with two of the factors are we have to believe Wade Wilson's statement to law enforcement on October 10th, because that's where the state gets a lot of their facts from. I will tell you that there are 2 mitigating factors that we agree they've proven beyond every reasonable doubt. One of them is because of the multiple deaths. That's a gimme, that's a freebie. The other is the fact that Mr. Wilson was on probation on or about the time of the event. So those are freebies, we're going to call them, and they're going to be given whatever weight you think that they deserve, which I submit to you isn't much. The other thing I want to point out before we get rolling here is if I say anything during my closing that you think is a criticism of your decision in the first part of this case, it's not. And I want to explain, we've gone into all this mental health mitigation. We're not trying to excuse Mr. Wilson's conduct on October 7th. That's not what this is about. But we are trying to show you what kind of person he was and why he was that kind of person on that date alone, and why he doesn't deserve your recommendation for death. Let's start with cold, calculated, and premeditated. Ms. Melton. Now, the state told you just a minute ago, well, you know, he was partying, he was having a good time, he was doing cocaine. When was he doing cocaine? And do we know that he was actually doing cocaine? Or was he doing what he told you later was maybe it was fentanyl, maybe it was flakka, maybe it was bath salts? He doesn't know, because he's never had a mental health experience from taking controlled substances like he did on October 7th. And when did he actually take those controlled substances? It wasn't before he went out and partied. It was after they went over to Mr. Shepard's house. Because if you recall Mr. Shepard saying, well, I had my own cocaine. Well, if you were using your own cocaine, what did you give Mr. Wilson?
What? This is your argument?
Mr. Wilson was okay from 2 to 4 there at Mr. Shepard's house. He and Ms. Melton are doing what adults do on occasion. That's their own private business. Eventually, they had to leave the residence. Now, how is Wade Wilson planning all this? We're going to go to this residence, we're going to leave this, we're going to go to this residence. How is that part of a grand scheme of anything? Well, it's not. It's circumstances happening. So they leave Mr. Shepard's, they would go over to Ms. Melton's with Ms. Johnson. Was that part of the plan for Ms. Johnson to come along? Now, oh my gosh, I'm going to have to wait now till Ms. Johnson leaves before I murder Ms. Melton? No, that wasn't a plan at all. There was no plan. He was freewheeling. He was having sex with this willful participant. He was having a great time. In his statement to law enforcement, he tells them there was no planning. After Ms. Johnson left, all of a sudden something came over him, and he strangled Ms. Melton. Now, we're talking about all the pain and suffering and everything else that Ms. Melton felt. We don't know any of that. We know that there are injuries. We know that he suffocated her asphyxia. I can't even pronounce it. But he choked her to death. He put the big hands around her. He cut off her blood supply through her carotid arteries, and she stopped breathing.
Being callous about this
I
murder
asked
is
their
not the way
medical
to approach
examiner,
this.
was she even conscious at the time that she died? He goes, I don't know. I can't tell you that. He couldn't tell us that about either of the victims. He wraps her up, and he's going to take her and hide her someplace. But it's getting too light outside. And according to his statement, if you believe his statement, she was too heavy to pick up. She was too heavy for him to pick her up and put her in the trunk? Or was it just getting too light outside? Or what is the truth? We don't know. But the state's trying to tell you that all of this stuff in here is the truth. And it's not. Cold, calculated, and premeditated as it relates to, wait a second here, as it relates to Ms. Ruiz. Well, he went over and he had an altercation with his girlfriend, back in the car. Then he's just out driving around. He's out driving around and he stops and asks directions. At some point in time, when did he make a decision that she was going to be a victim? She climbs in the car, they drive down the road, and all of a sudden, he snaps again, and he reaches over and chokes her. We don't really know where this occurs because the questions they asked of Mr. Wilson on the 10th aren't very probing. All we know from Mr. Wilson is that she wanted to get out of the car. He reached over and choked her. He drove her someplace. He opened the door, tried to push her out of the vehicle. When she hit the ground, all of a sudden she got up. At one point in time, he says one time. At one point in time, he says 3 or 4 times she was a real fighter. Is any of that true? We don't know.
He's playing both sword and shield with that confession.
Is it all reflected in other forensic or physical manifestations? Some of it may be yes. Some of it may be no. Obviously, if he ran over her 10 or 20 times, that's cold and calculated. That's where she was found. Let me get out of the way so you can see the picture. That's where she was found. Do you see tire tracks in that photograph that would substantiate him running over her 10 or 20 times? The clothing is still on her. Does that substantiate him running over her 10 or 20 times? No. Why? It's a lie. He's embellishing. Why is he doing that? Who knows? He's sick. He's got a diseased mind. We can't relate to that. It's hard for us to know what's going through his head when he's talking to law enforcement. Going back to the drugs, in his statement, it must have been like bath salts or flakka. It just made me lose my effing mind, and it made me effing get crazy. When I'm sober, I'm actually a decent guy, which is what everybody else said. Whatever that dude had me on, like fentanyl, flakka, whatever the F it was, dude, it was not cocaine. I thought it was different, and he gave me a lot of it. That shit had me up for 2.5 days. Once again, that's not an excuse for doing what he did. I just want you to understand what his state of mind was when he was going through these events on October 7th. And that person is not Wade Wilson. And that person does not deserve your recommendation for death. Heinous, atrocious, and cruel. Once again, I'm not going to repeat what I just told you about cold, calculated, and premeditated, because it applies to heinous, atrocious, and cruel. Now, even the prosecutor told you that is not the aggravating factor. The aggravating factor is especially heinous, atrocious, and cruel. Well, he strangled both these women to death, all right? Strangling in and of itself is heinous, atrocious, and cruel, according to the state. So it would be much better if he walked up and put a bullet in the back of her head because she didn't see it coming, or stabbed her to death from behind because she didn't see it coming. Not all homicides are especially heinous, atrocious, and cruel. And when your medical examiner gets up there and he says, I can't tell you if she was conscious when she died. Well, if she wasn't conscious, then she wasn't experiencing the pain and the panic that the state wants you to believe.
I can see this backfiring.
Now, we subjected you folks to 3 gentlemen who have degrees that presumably we don't have, who got up on the stand yesterday and talked about mental health. There are other mitigators. The state went through the mitigators. Some of them have been proven to you. I'm not going to go through all those mitigators. I will tell you that the initial mitigators, and this isn't the whole list. You may have the rest of the list on your legal pads there. You may have taken something down about Wade Wilson that's important to you, that's important for you to consider as to whether or not you're going to recommend that he die. But this is a partial list. And part of the partial list is when Wade Wilson is not on drugs, he is charming, he's polite, he's cool, he's in a good mood, he's friendly, and he's outgoing.
Well, why don't we just let him go then and
Well,
just
who
have him
was
not do
that
drugs?
on October 7th?
No.
That wasn't Wade Wilson. Not according to the people that know Wade Wilson. This isn't his family. This is the people that were with him. This is the people that know him. That's how they described him. Wade Wilson confessed to law enforcement to do the right thing. Wade Wilson wanted to put Ms. Ruiz back with her family so they could bury the body. That's what he told law enforcement. Well, the state wants you to believe his recitation of what happened is factual, but that isn't. So, what do you believe out of Wade Wilson's statement, and what don't you believe? You got to be hard-pressed to want to vote for death when you don't even know what the truth is. Our doctors, they all have different qualifications. The state first addressed Dr. Mills and basically brushed his testimony under the rug. Dr. Mills has been a psychiatrist for almost 50 years. Dr. Mills was the director of the largest mental health facility in North America with thousands of employees, hundreds or thousands of doctors working under him. That deserves your respect. Now, he would like to have had a lot more evidence, a lot more contact with Wade Wilson, but that was not to be. So, I threw him up on the stand and kind of hung him out to dry. Well, you didn't have a lot of time with him, no. But the time he had with him, he figured Wade Wilson out. What else did he use? He used the documents.
Oh my goodness.
Presumably the same documents that Dr. Herkov looked at, and he came up with diagnoses in those documents. Now, we didn't have a lot of the documents that we'd like to have had. You heard there's a fire at his parents' home, and all those documents from when he was younger are gone. What we had is what we had. But what was interesting was the last thing you heard yesterday. After Dr. Eisenstein had told you when he reviewed the records, there were many examples of medication that were provided to Wade Wilson as recently as 2022 or 2023. And then Dr. Mills got up there and told you what they're for. They're not this sissy stuff that Dr. Herkov testified to.
Sissy
They're
stuff?
the real thing. They're antipsychotic drugs. They're there to help treat the psychotic disorders that are listed amongst our mitigators. You can't just ignore that. Now, I think half of Dr. Herkov's testimony was all about him. What did he do? Well, he looked at some of the state's evidence. He looked at some videos of Wade Wilson when he gave a statement and Wade Wilson when he was in the vehicle. And he didn't see that Wade Wilson exhibited those disorders while he viewed it, those two relatively short videos. But he went through the records. Like I said before, presumably the same records everybody else had the opportunity to look at. And he didn't find any examples of either medication or diagnosis. Dr. Mills did. Dr. Eisenstein did. But in all fairness to Dr. Herkov, he didn't have the documents very long. And I submit to you, he just missed it. He said he went through them in an hour or two. I don't know how you go through a stack of papers in an hour or two and expect to find anything, but that's what he told us.
But he billed for 20 or 30 hours?
So we're going to let him off the hook. Dr. Eisenstein, but he was very helpful on two things. Dr. Eisenstein spent the most time with Wade Wilson. Dr. Eisenstein put Wade Wilson through several tests. Let's see. What Dr. Eisenstein, what Dr. Herkov did was take the tests that Dr. Eisenstein performed, take the raw data, and he made little charts that we got to look at yesterday. And I agree. On certain things, Wade Wilson is normal. He even was the top of normal, of average, in a couple of things. But there were some of the tests where we talked about memory. Tests that would have been important to know those results before we take his statement for granted. Auditory memory number 1, auditory memory number 2, perceptual reasoning, visual memory 1, visual memory 2. All 5 of those tests, he was anywhere from the bottom 5 to the bottom 2%. Only 4 people or 1 person was worse than he was. Executive functioning. Well, on 3 of those, he was fine. He was at, well, fine. 4 of those, I'm sorry, I don't want to mischaracterize. On 4 of them, he was fine. He was anywhere from 25% to 50%. He's still in the bottom half. But on the WCST-PR test, he was in the bottom 1%. It doesn't get any lower than that. As a matter of fact, it was probably below that because Dr. Eisenstein told you it was 7 deviations below average. And it was almost negligible as far as trying to calculate his result. And the Dallas Kaplan executive functioning, he did real well on most of them. But on VF category and VF switching, he was either the bottom 5% or the bottom 3%. There's something wrong with his brain. It doesn't work like everybody else's does. Do we know exactly what's wrong? No. Why? Because we only have some CAT scans that don't tell us very much. It tells us if we have a cracked skull. It tells us if there's bleeding under the skull. Well, what do we need? We need PET scans. We need MRIs. Do we have any of those? No, we don't. So you want me to sit here and tell you exactly what's wrong with Wade Wilson? I can't do it. But there's something terribly wrong with him.
What more do you need to see?
Oops, that was me.
Now, drugs. Well, you know, just because you're a drug addict, we're not going to not consider the death penalty because you're a drug addict. It's not that he's a drug addict. He took drugs. He started taking drugs at 13. What drugs he's taken over his lifetime, we're not sure. What's the frequency that he's taken the drugs over his lifetime? We're not sure of that either. All we're sure of is that night he was given drugs. What drugs, we don't know. But one of the gems from Dr. Herkov yesterday, as an example, if you have a disorder and you feed that disorder, just say cocaine, what does that do? That amplifies the problem. Well, what if it's another drug? What if it's one of these synthetic drugs that Wade Wilson complained of? What does that do to Wade Wilson when he has a mental health issue? Well, he took it himself. I know he took it himself. You're not rewarding him. You're just trying to decide if you want to take that guy who's cool, who's polite, who's charming, who's friendly, who, in his own words, fucks up one night and does that. I'm going to go back, and I apologize for going in reverse on something here. But, one of the troubling things in the allegations is the fact that he ran over her. We've already discussed the fact that we can't see all these tire marks and stuff from where he ran over her all these times. But we do have a law enforcement agency. And they were at work, and what did they do? They seized the black vehicle that he was riding around in. And what did they do? They took a swab inside and found blood that belonged to Ms. Ruiz. But what else did they do? They swabbed the front of the vehicle. Okay? And we heard testimony about what they got from... Oh, we didn't. We didn't hear any testimony, did we? Why? Because law enforcement agency didn't bother to send that swab off. Didn't bother to get it tested. a piece of evidence that you could have had, that you didn't have, that would have supported the state's contention that Mr. Wilson is telling the truth on October 10th, and you don't have it.
This is the penalty phase. We've already established guilt.
I'm not going to bore you with a lot more argument here. You people have a hard enough time in front of you. But there's just a couple of things I want to stress. I mean, somebody in their right mind, he kills a woman and leaves her in her home because it's getting too light outside. So then he goes to see his girlfriend. And he attacks his girlfriend in broad daylight in front of a bunch of witnesses. Then he leaves. And it's still broad daylight, and he goes riding down a road and picks up Ms. Ruiz and later kills her. Does that make any sense? You know what else doesn't make any sense? That's Wade Wilson in October. That's Wade Wilson now.
Because he's the guy.
Who in their right mind does that to themselves? He's not in his right mind all the time. And it's worse when you throw drugs on top of it. When he was a little boy, what did he do? They found him wearing a long-sleeve shirt with the shirt stapled to his arms. This isn't something that just occurred overnight. This is something that's been growing in Wade Wilson for a long, long time. Now, we heard from relatives of both Ms. Melton and Ms. Ruiz, and I'm sure that there were more that may have wanted to come up, and they wanted to tell you about their loss. We can't fix their loss. They have a hole in their heart. And the only way you can fix that hole in their heart is with love and friendship and fellowship and companionship, and hope that it shrinks the hole in their heart. But you can't fill the holes in their heart with another body. We can't bring these ladies back. There's nothing that you can do to fix that problem. But you can do the right thing here today. I want to, let me see here. Too many papers. Bear with me a second. We have an exhibit. That exhibit's in evidence. And I'm certainly not going to read the whole thing. You've been very attentive and very patient with me, and I appreciate that. For many years, we held on to the hope that nurture would overcome genetics. He was a wonderful kid, kind to animals, kind to those smaller than himself, and loving to his family. But there are many things in life that are out of our control, and it wasn't enough. Wade, like his birth mother, became a victim of his diseased mind. Know that he did not choose this, not any of it. He fought hard against the genetic pull of mental illness and drug abuse. But the man before you is fallible, and he is human, and he lost that fight. As his family, we knew the happy and loving child that he was. The boy who wanted to spend time with his parents and sisters. The one who played sports and loved to read. That person would never do the things he has done. That boy is still in there somewhere, but is now overtaken by the monster of disease and addiction. There's a concept, it's not a concept, it's a gift, that each one of us has the potential. It's something that makes us different from everything else in the animal world. It's a concept known as mercy.
Oh, I was thinking it was like opposable thumbs or something.
When you were selected to sit on this jury, we talked about the jury instructions and those types of things. And the primary theme here is you do not have to vote for death. There's nothing to suggest that you have to vote for death. If the aggravators outweigh the mitigating circumstances, you still don't have to vote for death. We can't love him less because madness has taken him from us. Lock away the monster, but show mercy to the boy inside who didn't choose this path. Know that boy is still in there somewhere, and he is still loved. Lock away the monster.
So that was different.
All right. Members of the jury, you have heard all the evidence and the argument of counsel. Now you must decide whether the defendant should be sentenced to life in prison without the possibility of parole or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving a death penalty. An aggravating factor increases the gravity of the crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state in count 1, first-degree murder of Christine Melton, are 1. Wade Wilson was previously convicted of a felony and was under sentence of imprisonment or on community control or on felony probation at the time he committed the first-degree murder in this case. 2. Wade Wilson was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to another person. A. The crime of first-degree murder is a capital felony. B. The crime of first-degree murder is a felony involving the use or threat of violence to another person. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Christine Melton. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim or justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You've heard evidence about the impact of this murder on the family, friends, or community of Christine Melton. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Christine Melton's death. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction it is one which is not stable but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proved by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstance exists. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances need not be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances for each count you may consider are: 1. When Wade Wilson is not on drugs, he is charming, polite, cool, good mood, friendly, and outgoing. 2. Wade Wilson experienced the following mental health disorders: schizophrenia, schizoaffective disorders, delusions, paranoia, suicidal adjustment disorders, major depressive disorder, hallucinations, and perseveration. 3. While Wade Wilson was on drugs, he is out of his mind, on a rampage, makes him crazy, and makes him do wrong things. 4.
These are terrible.
The drugs that Wade Wilson took that night before the event led to an unanticipated effect. 5. Wade Wilson confessed to law enforcement to do the right thing. 6. Wade Wilson wanted to put Ms. Ruiz back with her family. 7. Wade Wilson is loved by his adoptive parents and sisters. 8. Wade Wilson felt abandoned by his biological parents. 9. Wade Wilson's mental illness started as a child. 10. Wade Wilson was involuntarily committed when he was a teenager. 11. Wade Wilson tried to reach out to biological parents when he became an adult. 12. Wade Wilson's biological parents were young and did not try to reach out to establish a relationship. 13. Wade Wilson was a loving son before mental health disorders. The final step in the process is for the jury to determine whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all the following factors. 1. Whether sufficient aggravating factors exist, and 2. Whether the proven aggravating factors outweigh the proven mitigating circumstances. The evidence that you have heard throughout the guilt and penalty phases of this trial should be considered as to each of the capital felonies for which you have found the defendant guilty, count 1 and count 4 of the indictment. However, in making your determination, you must consider whether the state has proven each aggravating factor beyond a reasonable doubt with respect to each capital felony individually, and you must not let your verdict as to one aggravating factor affect your verdict with respect to another. Likewise, you must not let your verdict as to aggravating factors in one count affect your verdict as to the aggravating factors in the other. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, if you conclude that the sufficient aggravating factors outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided a form to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. The aggravating factors alleged by the state as to count 4 first-degree murder of Diane Ruiz are: 1. Wade Wilson was previously convicted of a felony and was under sentence of imprisonment or on community control or on felony probation at the time he committed the first-degree murder in this case. 2. Wade Wilson was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to another person. The crime of first-degree murder is a capital felony. The crime of first-degree murder is a felony involving the use or threat of violence to another person. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that would show the crime was conscienceless or pitiless and was unnecessarily torturous to Diane Ruiz. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim or justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard evidence about the impact of this murder on the family, friends, or community of Diane Ruiz. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss of Diane Ruiz's death. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must consider additional matters to determine whether the appropriate penalty should be life in prison without the possibility of parole or death. First, each of you must determine whether any mitigating circumstance exists. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. A mitigating circumstance need not be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances for each count you may consider are: 1. When Wade Wilson is not on drugs, he is charming, polite, cool, good mood, friendly, and outgoing. 2. Wade Wilson experienced the following mental health disorders: schizophrenia, schizoaffective disorders, delusions, paranoia, suicidal adjustment disorders, major depressive disorder, hallucinations, and perseveration. 3. While Wade Wilson was on drugs, he is out of his mind, on a rampage, makes him crazy, and makes him do wrong things. 4. The drugs that Wade Wilson took that night before the event led to an unanticipated effect. 5. Wade Wilson confessed to law enforcement to do the right thing. 6. Wade Wilson wanted to put Ms. Rees back with her family. 7. Wade Wilson is loved by his adoptive parents and sisters. 8. Wade Wilson felt abandoned by his biological parents. 9. Wade Wilson's mental illness started as a child. 10. Wade Wilson was involuntarily committed when he was a teenager. 11. Wade Wilson tried to reach out to biological parents when he became an adult. 12. Wade Wilson's biological parents were young and did not try to reach out to establish a relationship. Wade Wilson was a loving son before mental health disorders. The final step in the process is for the jury to determine whether the defendant should be sentenced to life in prison without the possibility of parole or to death. In making your decision, you must weigh all of the following factors. 1. Whether sufficient aggravating factors exist, and 2. Whether the proven aggravating factors outweigh the proven mitigating circumstances. The evidence that you have heard throughout the guilt and penalty phases of this trial should be considered as to each of the capital felonies for which we have found the defendant guilty, count 1 and count 4 of the indictment. However, in making your determination, you must consider whether the state has proven each aggravating factor beyond a reasonable doubt with respect to each capital felony individually. You must not let your verdict as to one aggravating factor affect your verdict with respect to another. Likewise, you must not let your verdict as to aggravating factors in one count affect your verdict as to the aggravating factors in the other. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote for the death penalty, the court must sentence the defendant to life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. This recommendation is not binding on the court. However, I am required to assign and give great weight and deference to your recommendation. You will be provided a form to reflect your decisions. The fact that the jury can make its decisions on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions. Weighing the evidence. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Did the witness's testimony agree with the other testimony and other evidence in the case? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to: 1. Whether the defendant made the statement, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2. Whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. The case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3. The case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. The verdict form is as follows, and I'll read it to you. In the Circuit Court of the 20th Judicial Circuit in 4 Lee County, Florida, criminal action, State of Florida versus Wade Wilson, case number 19 CF 568, jury verdict form, penalty phase. We, the jury, find as follows as to the defendant, Wade Wilson, in this case. As to count 1, first-degree murder, Christine Melton. A. Aggravating factors. Check either yes or no to each. 1. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. Yes, no. 2. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. Yes, no. 3. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes, no. 4. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes, no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations as to this count. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. B. Jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us have weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstances. We have further considered whether Wade Wilson should be sentenced to life in prison without the possibility of parole or death. Check only 1. We, the jury, find Wade Wilson should be sentenced to life in prison without the possibility of parole. We, the jury, find by a vote of blank to blank that Wade Wilson should be sentenced to death. As to count 4, first-degree murder, Diana Ruiz. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of A. Aggravating factors. Check either yes or no to each. 1. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation. Yes, no. 2. We, the jury, unanimously find that the state has established beyond a reasonable doubt that Wade Wilson was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person. Yes, no. 3. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was especially heinous, atrocious, or cruel. Yes, no. 4. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes, no. If you, the jury, answered no to every aggravating factor listed, you have completed your deliberations as to this count. If you, the jury, answered yes to any aggravating factor listed, proceed to Section B. B, jury recommendation. If fewer than 8 jurors vote for the death penalty, your recommendation must be for a penalty of life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. We, the jury, have unanimously found the state proved one or more aggravating factors. Each of us has considered whether one or more mitigating circumstances exist. Each of us has weighed whether the proven aggravating factors are sufficient and whether the proven aggravating factors outweigh any proven mitigating circumstance. We have further considered whether Wade Wilson should be sentenced to life in prison without the possibility of parole or death. Check only one. We, the jury, find Wade Wilson should be sentenced to life in prison without the possibility of parole. We, the jury, find by a vote of blank to blank that Wade Wilson should be sentenced to death. Dated this, place for the date, and for the signature of the four-person's
So
jury.
does the count? A vote of blank to blank?
Submitting case to jury. In just a few moments, you will be taken to the jury room by the bailiff. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate only about the case, only with one another, and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you have cell phones, watches, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the bailiff. During this trial, items received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate, or if you wish to see any exhibit not sent back to the jury room, please request that in writing. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. With that, everyone except juror 445 and 269, correct? Is that agreed by the state and defense? Yes, sir. You'll remain. And everybody else, you can take your notebooks, leave your cell phones if you have anything, and leave your watch here if you have things back there. The bailiff will get them and bring them back out. Yeah, we'll get that.
So we start the timer. I missed it. Can I start it now?
The record reflect the jury says the court of any objections to the instructions as read other than the ones noted before.
Your Honor, we did find mistakes.
I found a few.
Okay, so the one that Mr. Shirley pointed out was rules for deliberation. 6 and 7 should not have been on that because they were about proving the charge on reasonable doubt. So we have an updated copy to send back with the jurors that we both agreed to on that. It has 6 and 7.
So do you want me to reread the instructions?
What?
That specific one?
No, you can't just read one specific one.
What?
The way it's worded is hurts the state. if we send the corrective.
Wait, say that again?
The 6 and 7 put a higher burden on the state.
Unanimity.
Right.
And so it's not prejudicial to the defense. So for that reason, I think just sending the rules for deliberation instruction without 6 and 7 is sufficient. And that's what the state will be requesting.
Obviously, I would like what's beneficial to my client, but I don't think that that's right.
So what are you suggesting?
Sending the corrected instruction back.
But again, I believe it's a matter of, I believe I may have to read the instructions again if they weren't correct.
The entire package.
You cannot read one. You have to read the entire package.
This is terrible. This is absolutely terrible. This is why we went over it beforehand, guys.
And I read these in reliance upon the state and the defense both agreeing they were correct, but
let's shrink this down, move it over here, sorry.
We have just a 5 minutes.
well, I need to do something with the jurors back there. So
I think you can, all right.
Send Mr. Calvin out for one.
no.
Can we have 5 minutes to think this over? Judge is so mad. Okay, what's happening? Okay, this is a screaming goat moment for sure. After all the delays this morning, they screwed up the jury instructions. The state says, we've got the wrong thing in there. We need to make just one slight correction. And they say, go ahead. We're okay with you just correcting the copy and handing it to them. Judge says, that's not how it works. This has appeal written all over it. We're going to have to reread the instructions. All of them. So either we leave the instructions incorrect, which also
I think what
possibly,
I probably need to do, just for the record, the state's present, defense counsel, and defender are still present, that I'm probably going to have to bring them out and reread the instructions, just inform them that there was an error in the instructions and I need to reread them.
Which we're not going to stick around for. And he's mad. He's big mad.
I'll listen to anything else the defense or the state have.
No, unfortunately, I think that's the law.
And I've had the same problem with the state before in other
You
cases.
can't emphasize one instruction over the other.
Right.
Blaming the state.
All right, let's bring the jury back out.
Whoa.
I'm sorry, you're going to stay.
Stop. Stop.
Or actually, can they be excused, the alternates?
Oh, please.
The alternates are like, I am so
glad. So you all
Reset.
are the alternates. You can be excused. If you got all your stuff, okay.
Grab your eggs and go.
Thank you for your service, and you're excused. Yes, I think you are discharged at this time. All right. No, I got to bring them out.
The state caused this. The judge said, I've had this problem with the state before, which means these actors on the state side have screwed up before. We just excused the 2 jurors who are alternates. So we have 12 jurors who are deliberating. They only need to reach 8 to reach a conclusion of guilt or of the death penalty. Jurors entering, confused again. Or confused jurors entering. Let's get Nigel to make the announcement here really quickly. Listen to that sigh from the judge. Oh my goodness. The rules state he can't just reread one because that puts an emphasis over one rule over another. Oh, there's a shot. That high and tight doesn't do him any favors here. Okay, so what's going to happen? I want to hear the judge announce that and start reading. We're going to bail at that point, which means we won't have an...
Jurors entering.
Thank you, Nigel. We won't have an accurate jury counter on this one. I'm sorry, but I'm not going to stick around for that moment. But we are going to jump over and portal to our live stream, which is open right now for the Karen Reed closings, which we're going to pick up on that have been going on this morning. We're going to pick that up so we can get those caught up before the jury
Please be seated.
in Karen Reed reaches a verdict.
So, ladies and gentlemen, the jury, I read something in error in the instructions. Unfortunately, I can't just read one instruction. I need to reread all of the instructions, and I appreciate your patience, but I'm going to have to do that with the corrected instruction.
Really? So now we get all those close-up creepy shots again? And the state walks up with the new instruction
Also,
so you can see
can I
it's their
pass the
fault.
footage?
Just hook the other two down. I'll be right back.
The jury is really confused. Okay, we're gonna leave them right there. We're gonna leave them right there, and we'll jump back in a little bit. So I'll keep an eye on that. We won't have a timer, deliberation timer. I'm sorry, we're gonna have to just take it off. We won't have that because we're now going over to the Karen Reed trial for the closing arguments. We're told that each side gets how long? An hour. Let's see. Let me go back. Make sure we don't miss a word of it. Okay. There we go. And that's going to be on camera too. All right. There we go. Oh, wait. So wait. Cut. Pause. We have to portal. So here's what we're going to do. We're going to portal over so we can keep this all clean for people who want to rewatch this later. We have another one open in just a second. So we're going to portal all the way over to here again. It's going to take about a minute of me being down to get reconfigured and be back up. So it'll be really fast. What happens is after the music stops and the live stream stops, I have to wait till it finishes the feed, which takes about 10 seconds. Then the portal will appear. It'll say, please jump in, feet first, hands and feet inside the right at all times. You do that, you'll pop out on the other end. We'll be in a different courtroom. I'll still be dressed the same, but we'll be in a different place, and we'll be following the closings with it's science. You can't ignore the science. Yes. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe to go live again in moments in Canton. Hang on to everything. Bring your eggs. Guys, we're going to make this one quick, so have a good one. See you in a little bit.